Good morning and welcome to Trial TV Live. I am the Squeegee of Justice. Thank you so much for joining us today as we are going to be covering Shanda Vander Ark. Michigan versus Vander Ark. Will she get a new trial? Will she get a new trial? So while everybody is coming in, let's just review what happened. Back in 2022, little Timothy Ferguson there. She went to trial. She was accused of torturing her poor little kid there, her poor little son. And she did go to trial. She was found guilty. But now she is saying that she wants another trial because of her attorney. So I have a few news clips. They're scheduled to go on at the top of the hour at 9 o'clock. So I have a few news clips. So let's get to those before they start, and it'll kind of give us a background because we did not cover this trial. We wanted to do a rewatch, and we may still do a rewatch. That's still a possibility. But for now, I don't know that much about the trial, so I want to watch some news reports on it, and let's do that together. So welcome in everybody, and let me get to a couple news clips. So this is just that she got arrested, and so we're going to start with that, and then we'll go through her sentencing.
Information about the mother in Norton Shores accused of torturing her special needs son who died last week. Shanda Vander Ark is charged with open murder and child abuse. She appeared Friday in Muskegon District Court. 13 on Your Side's Charlie Tinker spoke with a county prosecutor.
The prosecutor didn't mince words. He said it was one of the most shocking cases he has handled in his entire 20-plus year career. You have allegations of this teenager being given ice baths, being deprived of food, and on the rare occasions when he was given food, being given bread or bread soaked in hot sauce. And what's worse, you have some saying this is a death that could have been prevented based on a situation out of Oklahoma, which the prosecutor told me had similarities.
There was some CPS involvement in the state of Oklahoma. That involvement involved similar allegations to what we were facing here in Michigan, that ultimately, as opposed to a court actually terminating her parental rights, my understanding is she voluntarily left the home. Now, what happens between that time, when that happens, and ultimately how she and the children get here to Michigan is something that investigators are still kind of looking into.
An exit order from 2012 from that Oklahoma juvenile court showed after Shanda Ferguson waived her custody rights, she was granted supervised visitation. A note there said that was only to be 3 hours per month, though it's unknown what has happened in the nearly 10-year span since that was decided. We'll have much more tonight at 6 when we dive deeper into her background. In Muskegon, Charlie Tinker, 13 on Your Side.
All right, so that was just the initial, she got arrested. Now we're going to watch, she did go to trial. She did go to trial and was found guilty. So I do want to still do a rewatch of this.
Breaking news right now, a Norton...
I would like to still do a rewatch of this. We might, we have it all ready to go. We just have to find the time to do it. So we may do a rewatch of this at some point. But if she has another trial, well, we'll do a rewatch of the first trial, then we'll go in if she gets, because today is just a motion hearing to see if she's even eligible. So let's see what this has to say.
Shores woman accused of abusing and killing her 15-year-old son over a year ago has been found guilty. Shanda Vander Ark refused to return to the stand today after answering questions from the prosecutor yesterday and even vomited after being shown photos of her son from hours before he died. Her defense attorney said Vander Ark waived her right to attend, citing medical distress. 13 Your Side, Jeremiah Brown has been in the courtroom all day and joins us now live with more. JD, what can you tell us?
Well, Elena, after an hour of deliberation, the jury had their verdict and found her guilty of first-degree murder and first-degree child abuse. Today, both the prosecution and the defense made their closing arguments to the jury, the prosecution reiterating just the extreme and unusual punishment she subjugated Timothy Ferguson to, including feeding him hot sauce on bread, starvation, and even restraining his hands and legs with cuffs. The defense said that she was not aware of that the punishments would ultimately lead to his death. This morning, the prosecution showed a video to those in the court taken from a camera Vander Ark had placed in the small room that detectives say was really a small closet that Timothy was placed in. The video showed Vander Ark and her son finding Timothy, who was unresponsive. 18 minutes passed before they called 911. Vander Ark can be heard telling her son Paul to help place him in another room and to make it look like he was found there. She is heard telling police that Timothy was on a hunger strike, which yesterday Paul testified saying was a lie.
And make no mistake, he was a prisoner in that home. We give prisoners rights. Timothy had none of those because the person charged with his care and custody refused them. Kept him locked up in the basement of that home with motion sensors and alarms to make sure he didn't even go upstairs, let alone anywhere else.
The prosecution also recounting statements from medical experts who noted that Timothy was 69 pounds when he was found, when the average 15-year-old male weighs 132 pounds, saying that Timothy was desperate enough to eat frozen chicken nuggets and uncooked hamburger. They said he was also found with signs of hypothermia in July, pointing to the ice bath he was also subject to. The defense appealed to the jury, stating that text messages lack emotion and situational context, and that yesterday Vander Ark read distorted images of past events. He also pointed to her personal circumstances to claim that she was not aware of how her actions would lead to his death. January 29th will be the date of her sentencing, according to the judge. He has also revoked bond and said that she is required by law to be present for her sentencing and to listen to victim impact statements. Live in Muskegon County, I'm Jeremiah Brown, 13 on your side.
All right, so that was her being convicted. Jury found her guilty. Now we're going to watch some of her sentencing, which, as he said, was in January, which was, I think, last year. I don't think it was this year.
Turning now to Michigan, where Shanda Vander Ark was sentenced to life in prison without the possibility of parole after being convicted of killing her 15-year-old son.
You testified yourself how highly intelligent you were. In fact, that's the only thing that you testified to that I think was actually true. You were quite proud of that, boasting how intelligent you were. Quite frankly, there's a mother's love that I've seen that is striking, and anybody who's a parent who's married, like most mothers, and not all, but most mothers have such a strong love for their children, and to see what you did to your own child. I don't know if there's a word in the English language to describe how to describe it. I only can come up with just horrific. You know, toward the end of these text messages, you and Paul are talking about not wanting him to win. He's not going to win. I didn't allow pictures to be shown in open court of Timothy as he was when he died, because I didn't want people to remember him like that. But of all the things you took away from him, one thing I didn't want you to take away from him was at least some shred of dignity. A beautiful child with a lot of life in his eyes. That's who your son was. And you took that from him. I'm choosing to remember him as a happy individual with life, not as an individual. And that's the picture I want people to remember of your son. You took that from him. You took it from him. For what reason, I don't know. Mr. Johnson's right. There is something broken in you. I don't know what that is, but it doesn't negate what you did here. So besides remembering him like that, I'm not going to let you hide in the darkness anymore. People know what you are now. They know what you did.
Police found Timothy Ferguson dead and severely malnourished inside the family's home. The few photos of the victim taken around his death were deemed too graphic to be shown to the public, but this photo here was shown today in court. A jury deliberated for a little more than an hour before finding his mother guilty on all charges. Today at sentencing, her two oldest children addressed the court.
Timothy was so smart. He could take anything apart with any tools or none at all. He had trouble focusing, but when he did, he was just as smart as the rest of his class. He made people angry, yes, but then he would look at you with those big baby blue eyes and you could never stay mad at him. I knew him his whole life. I held him the day he was born, and I continued to try to hold his hand as long as he was by my side, until he wasn't. I want the woman who killed my little brother to face the highest punishment possible.
All right, I just want to back out of that for a minute because it's going to be starting in another couple minutes. I just want to get to why there's a new trial, or I'm sorry, why we're even here today.
Most tragic part.
All right, so this is the prosecutors talking. So let's just find out. Prosecutors explain what the new hearing means. So let's hear what these guys have to say.
And for whatever deficits he might have had or difficulties that he had, he still was a human being of 15 who understood on some level what was happening to himself, that he was being denied these basic necessities, the food and the water and frankly just love and nurturing, and being denied those things and feeling himself slipping away to the point of death. And the people that were supposed to be protecting him, the people that were supposed to be providing for him and giving him those comforts, were the very people that were inflicting these punishments upon him. And that's just absolutely heartbreaking to deal with.
We did have a meeting in chambers ahead of this, so I sort of could see what the writing on the wall was going to be, at least as it relates to the defense getting an evidentiary hearing down the road as it relates to the claims of ineffective assistance of counsel. If we're talking about the competency ruling, I'm not surprised by the court's ruling because I don't think that looking at the evidence and the record, I don't think there's another viable option for the court to make because there was no bona fide doubt as to whether she was incompetent.
I would agree, and certainly the history of the case, as the judge pointed out here, demonstrates that whenever things turned towards bad things for Shanda, whenever there was a development that didn't go in her favor, and certainly after the cross-examination, and as the judge pointed out at the preliminary examination, sort of made the same effort as the co-defendant was about to testify. It's just when things turn bad for Ms. Vander Ark that she conveniently gets these moments where she just can't focus and she's mentally not able to be there. And that is really not the same thing as what criminal competency is, and that came through in the judge's ruling. That competency is a different standard. It's one that you suffer from a mental illness or mental defect, and as a result of that, you can't participate in your defense and understand the nature of the proceedings against you. And we can't lose sight of the fact that Ms. Vander Ark is, for all intents and purposes, or at that time, was a lawyer. She had passed the bar. She had graduated from law school. She was waiting to be licensed as an attorney. So certainly that doesn't necessarily hold her to a higher standard, but it certainly demonstrates that she has a greater understanding of the legal proceedings than just your average person. It's really not uncommon in cases where there is a claim of ineffective assistance of counsel. In other words, the defendant saying that they were denied effective representation at the trial. It's not unusual for the judge to want that record to be developed, and that's what is going to take place at a later time. It's called a Ginther hearing that relates back to the case in Michigan that sets forth the procedure for the court to follow. So we will come back at that time, and our anticipation is that once the record is fully developed, that the court will see that there's no genuine issue there either, that Mr. Johnson's representation of Ms. Vander Ark was appropriate, that she received effective representation. The issues specifically that the judge raised, we think we are going to be able to counter with Mr. Johnson's testimony. So it's not at all unusual for this procedure to take place.
Going forward, typically when I handle these type of Ginther hearings, I will meet with the defense trial counsel, so Mr. Johnson in this case, sit down, discuss the claims that are being levied by the defendant to just see what the veracity of those are. I then also routinely look for corroborating evidence of either statement to see, because typically we have a defendant versus their counsel and whose story lines up with what the evidence is. So that's natural, I think, as a preparation tactic for any hearing, is to see what evidence you have and then prepare it and address for each of the claims that they have. So with it, I'll be looking at other competency evaluations that have been done but might not have been before Judge Kacel when he made his determination. I have already, in anticipation of this, tried to work with the jail to see if there's any body cameras or video footage to support any of these claims, things like that. So looking for Mr. Johnson's word, as well as anything else out there that might assist.
Once that claim is filed, that ineffective assistance of counsel claim by the defendant, that effectively waives attorney-client privilege. So we are able to have those discussions, as Heather was indicating, discussions with Mr. Johnson about trial strategy, about areas that would otherwise we'd not be privy to. But once you claim that your counsel was not effective, it opens the door for the prosecution then to be able to have those conversations and, in fact, present the outcome of those discussions in open court.
Since this case was at a trial level, I was assisting as needed with Mr. Roberts, and so I was aware of the evidence and things like that had been presented before the court. And I will say that this case is one that I don't think will ever leave me. The haunting nature of it and just the sheer depravity. So we as prosecutors try to compartmentalize a lot of things in life, but I don't think this case is one that I will unfortunately ever be able to forget.
All right, let us get over to the live stream. See if we've got, okay, we do have, let's see here. We have a feed. All right, I will be back, and I'm going to get the Johnny Depp stream going, and I will be back in 1 minute. Just hold on. So checking in over here, still no feed, huh? Let's see if, yeah, still no feed. Well, doesn't surprise me that they're a little bit late. How's everybody doing over here? Twinkle Bell, hello. You owe us our favorite coffee or tea by our choice. Why do I got what? I owe you pizza? What's going on over here? I owe you coffee, tea, and pizza? Hey, Bama girl. McCormick family, what's everybody's plans for Thanksgiving? Just cooking. Yeah, we have to start. We started cooking on Sunday. We have to, we pretty much cook every day. We didn't cook yesterday, but every day we do a new dish. Hey, JP Rabbit, how are you? Ben says, they must be getting a late start. I don't think I'm ready yet to see this monster. I won't even use her name. This case disgusted me. What happened to the poor boy is sickening. Yeah. JMS, Super Ball and pizza. Hey, Dragonfly Girl. Good morning. So happy that we're covering this. Cool. Grab a seat. YT Hazel, hello to Stallwill. You made a difference in my day yesterday. Thank you for your kindness and friendship. Appreciate you. Thank you. Aw. Hey, BFM Cookies. What are you cooking today? Lazy boys. We might have to get our pitchforks and go to Michigan. Hey, Alice. Good to see you. Rita, you have sound now. Gina, good morning to you. Bama Green Eyes saying good morning to Hazel. All right, 9:13, so they're a little tardy. P. Cooper, what's up, man? I just thank you again for Johnny. I stay up so late in the UK watching. Enjoyed more with you than first time. Ah, awesome. Yeah, we're dual streaming today, guys, because we're continuing on with Johnny Depp, and this came up, so we figured we'd cover this one as well. Because we didn't cover it when it first happened because we weren't a channel, but we wanted to do a rewatch of it because it was just so incredibly terrible, but also we don't shy away from these kind of trials because we like to give a voice to the victims as well. So I still want to do a rewatch of this at some point. I think it was only like 4 or 5 days. I don't think it was a very long. Long trial. Jill, good morning to you. Let's see. Let me see if I get this right. I see Simone in there. D-Date Simone. Good morning. BFM, you're baking Christmas cookies. Right. Duh. Cindy, I watched some of this trial. It was before I started following here. Yeah, we did not stream it. It was, it happened before. It happened before we became a channel. Yeah, this was in 2023. We didn't become a channel until June of 2024. Northwest, you didn't see it either? Yeah, so maybe, we have it on rewatch. I made the thumbnails. We got all the videos ready. We were ready to go, but then live trials happened. So we will still revisit this at some point. Hey, Ruth, good morning to you. Teresa's making pumpkin rolls. Christine, it's a brutal trial. Yeah, from what I gather, I think I saw some body cam of her, Shanda, talking to the police, and it's sad. And one of her other sons helped. I think he pled guilty. I think. JP Rabbit says you would like the Adam Montgomery trial if you like this type of trial. Well, it's not that I like it. It's that we just don't shy away from them. I don't like these kind of trials where kids are, tortured. No, I'm not a fan of that. It's just I don't shy away from them because these victims deserve us to stand witness and be like, no, this was wrong. So, Adam Montgomery, you guys have mentioned that before. Jenny Lynn, lots of victim blaming coming out of her mouth. She said he was like on a hunger strike. Is that what it was? Crazy Mary Jo did not watch this trial. All right, so if we do a rewatch, then I guess we'll have some other people that did not watch it as well. Excuse me. Christine says he took a plea, but his face when he was sentenced was incredible. Okay. Clarinet says he got 30 to 100 years. Wow, that's a big jump. Hey, Mary. Good morning. Twinkle Bell's never heard of this trial either. All right. So we'll have to find a time to watch it when we have some downtime. Because like I said, I think it's only like 4 or 5 days. It didn't seem like it was that long. Northwest, any decision on Todd Mullis? I haven't really been paying attention, Northwest, so if it has happened, I would hope so. That was like a long time ago, right? It was this year, but I felt like that was like in May. It's been long enough, right? Don't you think it's been long enough? Twinkle Bells, yes, Monday next week. Brian Walsh, that's going to be the big one. Brian Walsh next Monday. Crazy Mary Jo, Adam Montgomery is very interesting and infuriating. All right. Lori, we're talking about this one, Shanda. This is, she was already convicted in 2023, and now she's asking, because ineffective counsel, she's asking for another trial. So that's what this is. She was convicted, and now she's asking for a shot at another trial. I don't know if she's gonna. Even if she's granted another trial, does she really think the outcome is going to be any different? Like I said, I didn't watch it, so I don't really know. But I don't really know what the evidence was per se, but it sounds like it was pretty overwhelming. All right, 9:19 here on the East Coast. Hey, Itchy Withers, good to see you. Carol, new trial for you too. All right. So if we cover it, we'll know that we have some people. We have some people watching it. So that's cool. Mary, it's worth a watch. Her antics were incredible. I think we have her as an ego takes the stand as well. Den Ben says, just like the other case in the news about the family starved a 14-year-old, but that child survived. Oh, yeah. There was like her father, stepmother, her sister or something. I kind of saw that. Saw a little bit of that. Angelique, he definitely thought helping the state he was going to get great leniency, but his TikTok and Facebook, he was starving for attention. Minimum of 30, maximum of 100. That's such a wide range. Ruth, you watched this trial. I always hope Shanda is enjoying your time, trying hard to still have control of others. Hey, Jen, good morning. Thank you for joining us. Selena, you watched the Adam Montgomery trial, wanted to just cry. Rita, you watched it, and you're from Muskegon, where it happened. Seems like it lasted forever. Yeah, we watched this morning. Aaron had it on while we were kind of milling about and eating breakfast and doing our thing. The officer's like asking for her identification, Silver Fox, and he's like, it's not like you were wanted for murder, is it? Not yet. B. Michigan, good morning. You watch this trial, vile situation. I don't think she should get a new trial. Northwest, the best attorney in the world couldn't get her not guilty. Yeah, I don't know what the evidence was, but it certainly didn't seem like she, it doesn't seem like she was, it seemed like the evidence was pretty overwhelming. Jenny G, good morning to you. Selena asks, why don't these monsters call someone and get the child taken away from them? Who knows? I don't, because that's not what they want. They want something else. They want something else. They don't want the child to be safe and protected and in a good environment, right? Dreamhorse says, I believe she got top marks in law school. No, well, the trial happened, but this is her asking for another trial. So this is live. So the trial actually happened in 2023, but she's asking for a retrial. So she went to trial, was convicted, was sentenced, and now she's asking for a retrial. That's where we stand. BFM asks, anyone know how many children? I thought 4, because 2 children came in to talk at sentencing. One got sentenced, I guess Paul is his name, and then the boy who passed away, who she killed, Timothy. So I guess she had 3 boys and 1 girl, it sounds like. Grizzly Snark Tree Hugger, good morning to you. Thank you for joining us. Let's see here. Mikazador says only 2 were at this home. Okay, so 4 altogether, right? Because two testified at Trial TV Live saying Grizzly Snarky Tree Hugger, welcome in. 2 testified at her sentencing, and then 1, obviously, Timothy, passed away, and then the other, Paul, was convicted as well. So to me, that sounds like she had 3 sons and 1 daughter. Again, I don't know very much about this trial, so I can't Karen says you'll watch it with us. Watch it again. Cool. All right. All right. Gina, thank you for all that you do. Love the chat, Kitty Cam and Tunes. Thank you, Gina. You know I always like your profile picture, your Dark Side of the Moon profile picture. I always give you a shout out for that. Oh, Teresa, she has 5 kids. Okay, so what? I got the 4 boys and the 1 girl. So where's the 5th one? Where's the 5th one come in? Hey, CJ says hello to you. 2 were older. So those were the 2 that talked at sentencing. Bama girl, and then the one Timothy passed away. 1 was sentenced, and then did she have a younger one then? Oh, she had a younger one who was about 7. Okay, thank you, Jojo. All right. So was that was a boy too? So she had 4 boys and one girl. Is that how it worked? There. Okay, thank you, Bama. You saw the wheels turning. So 4 sons, 1 daughter. All right. Alex, is this a motion for a new trial? Yes. Yes. It's a motion for a new trial. As it says, ineffective assistance of counsel motion. So it's right there on the screen. She's asking for a new trial. This is just a motion. So Lynn says you didn't watch it either, so you'll be here with us. Cool. All right. So we'll do it. We just have to find the time to do it well, Brian Walsh is Monday, so we'll cover Brian Walsh for sure. Golden Girl, good morning to you. You're cooking and baking. Dreamhorse, she had young children with another husband at the time. Okay, so 4 boys, 1 girl. Got it. Got it. 5th was younger. Thank you, Christine. Appreciate that. Mikazador says the other kids lived in another state and were older. Yes, I would watch again here. Cool. D Nice, I remember she directed the older child to torment him. Just terrible. Just terrible. Mary says the 5th was a child living in the same house. Okay. All right. Thanks, guys, for letting me know. Terry, good morning to you. Yanin, count me in for a rewatch as well. Cool. 4 sons, 1 daughter. Okay. Got it. Thank you, Karen. Robin, good morning. I'll rewatch it with you too. All right. We'll have to maybe at the end of the year, because there's no courts around Christmas and Christmas into New Year. So basically the 23rd, 24th, 25th until the New Year. So maybe we can watch her then. Maybe we could watch it then. I have no idea why they're late. This is, who knows? Half an hour now. Clarinet Girl sent an email about Sean Higgins. Okay, thank you. I'll go check that out when we have a break. Thank you for that, Clarinet Girl. Ned Denben, yes. Wonder why it hasn't started yet. Is she having a moment? Is she vomiting again? That's just wrong. That is just wrong. Mariner Mom, if she gets a new trial, what about her son that was convicted too? Yeah, that's a good question. That's a good question. What happens to her son? Well, he pled guilty, right? He took a plea, so I'm going to go check in on our other stream. I'll be back in a second. Let's see. There should be a time difference, Robin. Michigan's East Coast. Yeah, no, Michigan is Eastern. There shouldn't be a time if it's 9:30 in Michigan. I mean, the upper Peninsula, the UP, but they're not in the UP. So they should be starting. They were scheduled to start at 9 o'clock. All right, I'll be back in a sec. All right. Hey, Gordon. Hello to you. It's just a motion hearing. So it's not going to be a full trial, and I don't think it's going to take more than an hour or two. But I don't know. I'm just speculating and guessing. So it's not going to be the full trial. Just going to be her trying to get a new trial. D Nice, yeah, 9:30 here in Michigan and raining. Allie B, welcome back. Hey, Scott, good morning. Thank you for being my background noise today. Cool. Northwest is telling Midwest people to check weather warnings. I guess there's something going through. Kathy, morning. I swore I would stay off here this week, but I have to see this. Well, it's like watching a train wreck, right? You want to look away, but you can't. You want to look away, but you can't. I get you. Let me see if anything's going on over here. Nothing. Nothing over here about saying why they're late. Yeah, I don't know. I don't know why they're not on time, you guys. If I knew, I would tell you, but I really don't know. So we just wait. We just wait and we hang out. They were scheduled to go on at 9, and here we are at 9:30. All right. Court TV's claiming that she has a medical. Oh, really? Jeez. Jenny G, it's only can't tag. Thank you, though. Oh, you can't tag me? Let me tag you. There. See if that helps. I don't know. Yeah, that's a good idea, Funkmaster, but I don't want to be in the middle of something and then they cut in, you know? It's like one of those situations where we're watching something and then let's see, what other news can we watch about her? Let me see if there's any like quick news clip. Well, we could watch her sentencing. Let me do that. We could watch her sentencing. We could watch her sentencing. And of course, as soon as I do this, they're going to come back. You know that. You know, as soon as I do this, they're going to come in. You know that, right?
All right, thank you, Mr. Johnson. Ms. Vander Ark, do you wish to say anything prior to sentencing? All right, thank you.
All right, so this is her sentencing. We'll play this. Let's see, let me put this over here. All right. So keep an eye on that. All right.
Thank you, Mr. Johnson. Ms. Vander Ark, do you wish to say anything prior to sentencing? Well, first and foremost, for the individuals here to speak on Timothy's behalf, I appreciate you being here. It kind of struck me throughout the trial, you know, who was here for Timothy. And at one point in time, I worried that we may not have anyone to give a victim impact statement. And that to me made me very sad, quite frankly. Horrified more than anything, but quite sad. And I'm happy that two individuals took time to be here from miles across the country. And out of the horrible situation, that makes me feel a little bit better. Not much, but a little bit better. You know, Mr. Johnson makes the same argument today that he made at the trial, that this was just negligence. This was her not understanding what was going on. She was really trying to do the punishment. She was trying to be a good parent, and she just didn't realize that Timothy was in such a horrible condition. And I found myself, especially during closing argument, quite frankly, finding myself almost believing that. And afterwards, after the trial, I sat in my car after leaving that day, trying to understand, why I could feel that way. And what I realized is that I wanted to feel that way because I didn't want to accept the reality of the situation here. And the reality of the situation here is that this person, Ms. Vander Ark, you intentionally engaged in these acts. This wasn't negligence. This is not understanding why, but you intentionally did this with a goal. And I think Mr. Johnson's correct. I don't believe there was an intent to kill here, because you would have lost the very thing that you wanted to torture. Without him, you have no one to torture, except maybe the younger children. So I don't believe you intended to kill him. I think you intended to continue on torturing him for as long as you possibly could. The why, I don't know. But all the information that I have in front of me, and I sat down, I really thought about this, and I looked over my notes from the trial, demonstrate that this wasn't negligence. This wasn't you not understanding what was going on. You look through, I read through every single text message of the exhibit, 2,000 plus pages, to try to understand what the heck was going through your mind. And what became entirely clear to me is that you knew exactly what you were doing. Immediately afterwards, when police arrive at the home, you immediately concoct this lie about he's been on a hunger strike. He was in the bed and I checked on him and I gave him some food and all this stuff. You got Paul involved in it. At one point in time, put baggy clothes on him. Put clothes on him to make sure, I guess, that he looks like he was actually wearing them, that he was hiding his poor condition, even though you already received text messages, weeks earlier of how bad he looked. You testified yourself how highly intelligent you were. In fact, that's the only thing that you testified to that I think was actually true. You were quite proud of that, boasting how intelligent you were. And not only that, but your actions in hiding this child. You hid him from his grandparents. You made sure that your other son, G, or little man, as you call him, didn't see him. Those text messages talk about not wanting anyone to see him. I want to see him in that condition. You made sure that the garage was closed when you sent him out there with no pants on to clean out the garage. I don't want to believe it because I don't understand. I can't wrap my mind. I've been trying now for this entire case to wrap my mind around how somebody could do something so horrific, not only to another human being, but to their own child. I'm a father myself. I love my kids. I love them with unconditionally. But quite frankly, there's a mother's love that I've seen that is striking. And anybody who's a parent who's married, most mothers, not all, but most mothers have such a strong love for their children. And to see what you did to your own child, I don't know if there's a word in the English language to describe how to describe it. I only can come up with just horrific. You intentionally and systematically tortured this child. And let's call it what it is. It's torture. You tortured this child. This wasn't punishment. This wasn't trying to curb his behavior. You tortured him. You monitored him obsessively. You all the things you did. I looked through every one of the messages. Bread with hot sauce, wall sits, up and down the stairs, sleep deprivation, ice baths, making him puke up food, monitoring his bathroom time, giving him 60 seconds in the bathroom if he went to urinated, or 5 minutes if he had a bowel movement. You made him sleep in the closet. You threatened us to make him sleep in the garage. You put Tabasco directly in his mouth. You made him put his hands over the head. Made him work in the garage with no pants. And there's two other things that didn't come out in the trial that were in the messages. One, that there was talk of blindfolding him, depriving him of his physical sight as a punishment. And the last thing that struck me is just absolutely horrific in terms of your thinking. There was mentioning of giving him salt water as a punishment. One of the text messages talks about, hey, tell Paul or tell Tim that I'm not going to do the salt water punishment. And your reasoning for not punishing him was that, oh my God, we can't get him salt water, that could hurt him, that could kill him. But it was because you didn't want to give him another excuse to sit down on the toilet because he'd have diarrhea. He'd have diarrhea, and so he would have an excuse to sit down for a few more minutes while he was diarrhea from salt water. That was your excuse. That was your justification, not that it would hurt him. And you did so for what? Because of some punishment. You wanted to regulate his food, even though you yourself testified that he didn't really gain a lot of weight. Toward the end of these text messages, you and Paul are talking about not wanting him to win. He's not going to win. I didn't allow pictures to be shown in open court of Timothy as he was when he died, because I didn't want people to remember him like that. Of all the things you took away from him, one thing I didn't want you to take away from him was at least some shred of dignity. And then I also thought, well, I'm a judge, I'm a human being. I don't know how to right this wrong. We try to do that. I try to do that from the bench every day. There's no way to right this wrong except impose a sentence that essentially takes away your freedom. And I thought to myself, what do I do? And I will tell you this. I am choosing not to remember your son dead, looking like a Holocaust victim, and I'm choosing to remember like that. And you can't even look at him. That's how he was. A beautiful child with a lot of life in his eyes. That's who your son was. And you took that from him. I'm choosing to remember him as a happy individual with life, not as an individual. And that's the picture I want people to remember of your son. You took that from him. You took it from him. For what reason, I don't know. Mr. Johnson's right. There is something broken in you. I don't know what that is, but it doesn't negate what you did here. So, besides remembering him like that, I'm not going to let you hide in the darkness anymore. People know what you are now. They know what you did. You're not able to hide in the darkness anymore. Timothy won. And he won because we know what you did to him now. It's not hidden anymore. We know who you are. That's the way that I'm going to honor him. You don't win because justice, thank God, in this case prevailed. I can't even imagine if you had been able to resuscitate him. He'd be still suffering. So if there's anything I'm grateful for, would be that he finally passed away so you couldn't continue to torture him like you did. The sentence of the court first says to count 2, child abuse in the first degree. Court sentences you 50 years to 100 years in prison. Credit for 575 days. Court is exceeding guidelines in this case. The court finds that the amount of torture that I've indicated in terms of the long-term suffering that Mr. Ferguson Timothy went through justifies on a reasonable grounds to depart from the guidelines. Used to be the standard was the guidelines. If the guidelines didn't take into consideration all the elements, I don't think they would take into consideration the amount of absolute systematic, consistent torture that you engaged in here. I think that's enough reasons to justify departing from the guidelines. There's a $68 state cost, $130 crime victim rights assessment. As to count 1, felony murder. It's a sentence of the court. You serve a term within the Michigan Department of Corrections for the rest of your natural life without parole. Again, there's credit for 575 days that you've already served. There's a $68 state cost. The crime victim assessment fee has already been assessed, and the court is going to assess a $450 public defender fee. Ms. Vander Ark, you have a right to file an application. You have a right to file an appeal Request for this, if you are unable to afford an attorney, one will be appointed to a public expense. Request for assistance of a lawyer must be made within 42 days from today's date. Clerk is handing you a form that you must complete, return to the court in that 42 days. Mr. Roberts.
Judge, just briefly, I believe you did indicate you would order that $5,000 in restitution.
Oh, I did. Thank you, Mr. Roberts. The court will order $5,000 in restitution at this time to the Michigan Department of Health and Human Services, with the caveat that Mr. Johnson, you can certainly, if after the documentation, you can certainly ask for a restitution hearing and to contest that amount.
Thank you, Your Honor.
Anything else for the record, Mr. Roberts?
No, thank you, Judge.
Mr. Johnson?
No, sir.
All right, we're adjourned.
All right, that was her being sentenced. So there's no shortage of things to watch. It's just what do we want to get into? We could watch Paul. This is Paul Ferguson. Do you want to see Paul's sentencing? We could watch Paul's sentencing. Again, there's no shortage of things to watch. It's just a matter of we're going to get involved in something, and then it's going to come on. Let's see what her son has to say. How about that? Let me see. So it's this one.
I asked the judge for...
All right, so this is her son, Paul, and his sentencing.
I asked the judge for nothing more than mercy and fairness, to offer me compassion so I might learn from him. I only hope to better myself in the coming days, and serve my time with what little honor I have left, and to make right my faults in search of a better tomorrow.
First and foremost, as Mr. Roberts referenced, the court was in a difficult position. This particular case, I think a lot of individuals saw Mr. Ferguson testify, and I think there was concerns about intellectual potential disabilities, and the court was concerned with that as well. There was also a concern whether Mr. Ferguson was the target of manipulation on behalf of his mother, and the reports that were submitted to the court really did help me a lot in trying to parse those issues out. The report specifically by Dr. Shazer is very in-depth and very well done, and I thank him for doing such a detailed analysis. So the first concern of the court was whether or not Mr. Ferguson was suffering from some sort of intellectual disability, whether it be autism or something else. And there's a couple references to that throughout his Dr. Shazer's report. And specifically, the first reference that the court had highlighted was on page 2 of the report's first full paragraph, and it says, in my opinion, he, referring to Mr. Ferguson, was clearly either psychotic or suffering from symptoms of a mood disorder at the time of the current interview, and he was apparently functioning within at least the normal range of intellectual ability at this time. Thus, in my opinion, he does not suffer from a chronic psychotic disorder, a chronic mood disorder, or an intellectual disability. There's another reference more to the end of the report where he indicates, thus, his referring to Mr. Ferguson, his educational history is inconsistent with him suffering from intellectual deficits, and as noted above, he was apparently functioning within at least the normal range of intellectual ability at the time of the court interview. In my opinion, the defendant clearly does not suffer from an intellectual disability. So the court, that was helpful in the court because and some of the letters that I received as well, Mr. Roberts indicated that there was concern that Mr. Ferguson was autistic. And I think probably more toward that was easier to maybe manipulate him and that kind of thing. And certainly the court does take someone's intellectual capacity into consideration. I think it's important to understand the full situation. So the court, and although those are two small portions of the opinion that the court referenced, they're borne out by much more in detail history in Dr. Shazer's report. Specifically, Dr. Shazer analyzed every statement that the defendant gave the police. He also watched the testimony of Mr. Ferguson, interviewed him himself. He also looked through his history from the Oklahoma Department of Health and Human Services. He looked through his history from school records, from various psychological assessments that were conducted throughout his life based on the report. So I think that opinion is well grounded in not only his interview, his review of educational records, his review of mental health records, and everything else, Health West records currently from when he was assessed when he became in the Muskegon County Jail. So the court finds that to be quite persuasive in terms of whether or not Mr. Ferguson is suffering from any intellectual disability. And the court concludes based on this report, well-written report, well-grounded in fact and history of the defendant, that he was not suffering from an intellectual disability currently or at the time of this offense. The second thing is whether or not Mr. Ferguson was somehow manipulated or coerced by his mother. I think all of us would like to believe that this is a product of manipulation, that this is simply somebody doing something that they were told to do, that they were afraid. Mr. Alvin Brady mentioned it in his allocution regarding the specific text messages. Well, those specific text messages I heard as well at the trial. Shortly after the trial concluded, I had asked the prosecutor's office for a complete copy of every single text messages that would occur between Ms. Vander Ark and Mr. Ferguson, because I didn't want just the snippets, the kind of highlights, or the real juicy stuff, for lack of a better term. I wanted to understand completely what the conversation was between these individuals. I read every single text message, every one of them. I think there's thousands in there, and I've read it 3 times now. 3 times in total. I read it 2 months ago, I read it a month ago, and I read it last week Friday. The entire afternoon was spent reading through these things, and I think it's clear to me that Mr. Ferguson, although he says that he was scared of his mother, or there's an allegation at that standpoint, I find that just the opposite to be true based on those text messages. There is some mention about punishment, but I think Mr. Ferguson, in my opinion, being submissive, for lack of a better term, to his mother was a result that he really had nowhere else to go. He had been kicked out from his father's house for failing to obey his father's rules and for other things. And he went to his mother's house, and I don't think Mr. Ferguson really had anywhere else to go. I think he was sort of beholden to his mother in terms of, well, there's going to be consequences. Although there are some text messages, 1 or 2 of those that bear that out, this strikes me in the text messages as more of a collaborative effort. In fact, there's some text messages where Ms. Vander Ark actually tells Mr. Ferguson that if Ms. Timothy does not behave, essentially, I'm going to leave him to you, as in that he's going to let the dog out and just bob off the chain. And Mr. Ferguson also several times essentially tells his mother things that are going on that are bad. And I think it's because he wants his mother to give him the permission to go ahead and engage in punishment. So in terms of whether or not his mother, he was somehow afraid of his mother, I don't think that to be the case. Now, That was my initial feeling about it, and what I took it as, and that's why I wanted the assessment regarding whether or not he was being manipulated. And luckily, we did.
All right. I see that they've kicked in, guys. So just give me a second. Let's get us here. There she is. All right, looks like she's made it. All right. We had a little audio. Now, Terry, thank you. Been a lurker for months. Love Trial TV Live. Thank you.
Circuit Court, County Muskegon is now in session. The Honorable Matthew Kacel is presiding. Please be seated. Good morning.
Before the court is file 23110 FC. It's people of the state of Michigan versus Shanda Vander Ark. Are you Shanda Vander Ark? All right. Ms. Vander Ark appears before the court with her attorney, Mr. Ambrose, Mr. Roberts, as well as Ms. Bloomquist are here on behalf of the people of the state of Michigan. Date and time, the court is scheduled for a Ginther hearing, and technically a continued hearing from the last time we were here. We're delayed. There's been some concerns regarding Ms. Vander Ark's health this morning. Mr. Ambrose, if you want to go ahead and make a record of any concerns you have at this time.
Yes, Your Honor. I had a video conference with Ms. Vander Ark on Friday, this past Friday. It was concerning to me because she didn't appear to be her normal self, and so that concerned me. So I did send an email to the court expressing an adjournment if possible, just because this is an important phase in the whole appellate process, and certainly of utmost importance to my client that she's able to participate in a meaningful manner. And during our conversation on Friday, it just didn't seem that she was as up to speed or healthy. She expressed some health concerns that she was undergoing at that time, and so that's why I asked for an adjournment on Friday. What I understand is that what she told me this morning is on Saturday she had an episode at the Huron Valley Women's Facility where she passed out for a short period of time, was revived, but she had a medical issue at that time. She's not feeling well today either. I know she was checked out by medical. Her blood pressure is higher than it is normally for her, as she self-reports. So I would be requesting an adjournment. It doesn't hurt the prosecution, I don't think, at all. It is, if anything, delaying this case keeps her in prison. You know, I'd like to move forward as if I could, knowing in good conscience that we're putting our best foot forward on a case like this, and have the 100% confidence that my client is able to participate in a meaningful manner. And I just don't think at this point I can, with any type of confidence, say that. So I would still ask for an adjournment. And I know that my client has signed a release for some medical records from Huron Valley Women's Facility to release at least the most recent episode that she had.
Okay, Mr. Ambrose, is she able to speak to you this morning?
Yes.
Not getting into what those conversations are, but are you able to converse with her this morning?
I can.
Okay.
She has a pounding headache, and it doesn't help. You know, it's a stressful situation. I'm sure that's part of the what happens in these types of situations. But yeah, I mean,
as an officer of the court, do you believe she's not competent to go forward? Under the Michigan, under the law in the state of Michigan, do you believe she is competent to go forward?
Yeah, I don't think she's incompetent, put it that way. Okay. I mean, she's able to communicate with me, yes, okay, but maybe, not at the best.
All right.
Especially with somebody that has a pounding headache. I mean, I can just imagine.
Did she take any medication for headache or aspirin or
I don't think they
ibuprofen or
any medication today?
Okay. Is that something she normally would take for a headache?
She's
okay.
Oh yeah, she does. She has a thyroid issue. She pointed out to me that it's protruding. She's undergoing testing. Won't know the results for another couple of weeks if it's cancerous or not. There is a family history of that as well.
Okay. Ms. Blomquist.
Thank you, Your Honor. Well, I was going to argue that she's presumed competent until she shows otherwise, but given that's not the claim, then the argument would be whether or not there's good cause for an adjournment, and it's the people's position that a headache is not good cause. Additionally, the people are ready to proceed and put, one, with the Ginther hearing, but two, we do have some evidence that we could set forth to make the record as it relates to her appearance and how she was on the transport on the way here. We did have after the in-chambers discussion, jail medical came and looked at her, and it seems that she's been cleared by them, apart from having somewhat raised blood pressure. So I do think that we could make a record as to why this is not good cause. Additionally, Ms. Vander Ark, through her counsel, did give a waiver of HIPAA so that we could request some records from MDOC. They said that those would be emailed to me in approximately 30 minutes. They were going to do that expeditiously. However, the people would put forth as an officer of the court that in communications with the Michigan Department of Corrections, they would not have transported her had there been a medical issue raised before transport. So, Your Honor, I think this is just, again, another dilatory tactic by Ms. Vander Ark to delay this hearing and to delay the proceedings. And I would say that there's not good cause. And additionally, I think the court can take into consideration all of the prior actions of the defendant, her prior reports, all of that when fashioning whether or not an adjournment is warranted. And it's not in this case, and we should proceed.
Okay. Did anyone, we obviously have the Department of Corrections officers in the courtroom. Did anyone talk to them regarding her condition?
I did, Your Honor. I did inform them they may be needed to take some brief testimony.
Well, short of that, are either one of you comfortable doing that?
If you would like us to, we can.
Okay, well, why don't we have one of, what's your name, ma'am?
Officer Scott.
Officer Scott, why don't you have you come on up and I'll swear you in. What's your first name, ma'am?
First name's Autumn, A-U-T-U-M-N.
All right, Ms. Scott, can you raise your right hand? This matter now pending. Do you swear or affirm the testimony you're about to give you the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, put your hand down and grab a seat. Can you please state your name for the record, spelling your first name and last name?
First name is Autumn, A-U-T-U-M-N. Last name is Scott, S-C-O-T-T.
All right, any objection with me asking some questions, and I'll let you guys follow up. Mrs. Bloomquist, Mr. Ambrose?
No.
All right, good morning, ma'am. I'm sorry you're in this position. This doesn't usually happen. So,
It's okay.
my understanding is you transported Ms. Vander Ark here this morning. Is that correct?
Correct.
And where did you transport her from?
Women's Huron Valley in Ypsilanti, Michigan.
Okay, approximately how long is that?
About 2 hours and 45 minutes.
Okay. And now, I kind of understand the configuration. Are you in the back with her in the van, or are you driving in the front? How does that usually work? Where's everybody in the van?
It's okay. I was driving. My partner was in the passenger seat, and Miss Vander Ark was in the back.
Okay. So you were more focused on the road?
Correct.
Okay. All right. So we probably need your partner more a little bit. Now, were you able to observe Miss Vander Ark?
I can see her through the rear view mirror as I drive.
Okay. Was she communicating with you at all?
She only spoke to us a couple times just to ask to turn the heat up or down.
Okay. Did she indicate that she had a headache at all?
She did not when we arrived. She did say that she was feeling a little nauseous,
Okay. All right.
a little dry heaving.
Okay. Anything from, was it? No. Okay. All right. You probably, did you ask her what it was from? Was it from the ride or something like that? Or you know?
She did say she does get car sick.
Car sick. Okay. All right. To your knowledge, would the Department of Corrections transport a prisoner if they had a concern over her medical health?
No, and if she would have expressed it to my partner, then my partner would have requested to have healthcare come and clear her before we leave.
Okay. All right. Okay. All right. Technically, Mr. Ambrose, this is your hearing, so unless you want to go ahead, Mr. Ambrose.
I don't really have anything.
Okay. Ms. Bloomquist?
Just briefly, Officer Scott, was she conversational?
She didn't talk much. Like I said, just to ask us to turn the heat up or down for her. Other than that, she was quiet.
Okay. You can stand down. Thank you so much. Do we want to put the other Department of Corrections officer on? Anybody input on that?
I'll leave that in the court's discretion, Your Honor.
Mr. Ambrose?
I don't have an opinion on it.
All right. Any other argument before I make a ruling on this, Mr. Ambrose?
Well, just that she did mention that she was nauseous, and that's consistent with, her headache, what she reported to me.
All right. Ms. Bloomquist, anything else?
Yes, Your Honor. I just would ask the court take judicial notice that Ms. Vander Ark, during this motion to adjourn, has actually been assisting Mr. Ambrose in the proceeding with writing notes to him about if she's taken any medication or if she has done anything to assist in in remedying her headache. So I think that I just wanted that to be on the record because I don't think the transcript would necessarily catch that. But as an observer in the courtroom, she has been actively participating in this motion through her counsel despite her claimed ailment. So again, I don't think there's good cause for an adjournment, and I'd like to move forward.
All right.
Your Honor, can I just say, just my client writing a couple of notes down, is that supposed to be some sort of active participation? I don't think so.
Well, Mr. Ambrose, we're kind of in a catch-22 because I can't ask you what she's been telling you, and what kind of, I can't judge how much she's assisting you without getting into what she's talking about. So I'm observing her writing notes and talking to you, which I've had jury trials where the defendant doesn't say anything to their counsel, and so why don't we do this? The court also has experience with Ms. Vander Ark. Several times during the proceeding, during the jury trial, there were breaks in time where Ms. Vander Ark said she was undergoing distress. I granted those breaks. It seemed to me, and from the outside looking in, that these medical issues seem to be at times of pretty significant testimony in the trial. Not saying that maybe they weren't genuine, but they certainly appeared to be situational. Also, when she at a preliminary examination down in district court, there was a point of what she claimed to be distress that appeared to be situational. We're here now, and I think it seems to be situational again. Again, she may be going through something, but I understand that, adjourning this would necessarily prejudice the defense. However, there's witnesses here. They're ready to go. People took time out of their schedules. The court set aside an entire day for this. And there is something to be said for the swift administration of justice here. And so, based on what I have, I don't think there's good cause for an adjournment based on a headache, because that's all really the record's been made. And the only person that can judge if she really has a headache or not, quite frankly, is Ms. Vander Ark. And I don't know if she's telling the truth or not. I have no clue. I will say, as the finder of fact at the trial didn't find her credible, and I don't know how much credibility the court can lay on her statements. So I'm willing to do this. I can take a break, wait for the records to come in. That way the court can review those. I also can offer Ms. Vander Ark, is our jail staff allowed to give her medication, like ibuprofen or Tylenol or something like that? Is that allowed?
I would assume if they discuss it with healthcare at the prison, that would be fine.
Okay. All right. So I don't, do we have something downstairs? She can, I don't know what she takes, Mr. Ambrose. She'll let me know. I'm sure they have it all on. We can do anything we can to help with that. I'm willing to give her, if she needs for blood pressure, I don't know, maybe she needs food or something. I don't know what it is. So anything that can accommodate to help her headache, I get it. If she's got a pounding headache, then I want to at least try to get her some help for that. So why don't we adjourn? We'll wait for the records to come in. Mr. Ambrose, let my staff know if she needs medication, and we can get that from the jail. And then we'll go from there. Anything else before we break, Ms. Bloomquist?
No, Your Honor.
Mr. Ambrose?
No, thank you.
Okay, we're in recess.
All right. So they're going to recess for how long? We don't know. The good thing is she's still in jail, right? It's not like she's, out walking the streets. So, she still is in jail. It's a waste of time for sure. It's a waste of state's time, her attorney's time, the judge's time, our time. But bottom line is she's still in jail, so it's not like she's getting anything, I don't know. Just send her back to jail and do it another time, I guess, right? But it's getting everybody together. That is a big waste of time. All right. So I'll play some more stuff. Let me grab some other stuff. We were in the middle of Paul's sentencing. Do you want to pick up back on that? We could watch that again. Let me see. We can go back to this. Let's see, where were we? Yeah, we still have a little bit to go. So we'll pick back up on Paul's sentencing, because who knows, this could be an hour. It could be a half hour, an hour, it could be 5, I don't know. All right, we'll pick back up on this.
I did get one from the second one I referenced was from Dr. Farhad, which is specifically, I think he was asked to assess this particular question, and in the beginning of his assessment, he says that specifically, I was asked to assess whether Mr. Ferguson possessed a psychological disorder of traits that would render him significantly susceptible to manipulation, coercion, or suggestibility. After conducting the evaluation, I could not substantiate these traits as they pertain to the commission of the offense. As such, this report will instead explain the nature of the evaluation and my overall opinions regarding Mr. Ferguson's psychological functioning. He also opined regarding his intellectual abilities. He says, from a diagnostic standpoint, I did not find sufficient evidence to support Mr. Ferguson meeting criteria for any specific mental disorder. While one may consider whether his presentation suggested a neurodevelopmental condition, for example, e.g. autism spectrum disorder, I did not find this to be an appropriate label. Instead, I attributed his overall demeanor and presentation to factors such as a lack of socialization, normalization of abnormal dynamics and experiences, poor interpersonal skills, and emotional dysregulation. He also indicated later on that page that I was initially asked to evaluate whether Mr. Ferguson had a mental condition or traits that would have rendered him susceptible to coercion, manipulation, or suggestibility at the time of the offense. Ultimately, I could not arrive at this conclusion based on the totality of the available information. Available evidence noted that he was capable of appreciating the abuse towards his brother, that he was capable of recognizing the detrimental impact it had, and that he at times disobeyed Ms. Vander Ark and tried to provide his brother with aid and support. Furthermore, despite reporting that he was under Ms. Vander Ark's, quote, psychological hold, he adamantly denied that he was coerced or manipulated into enforcing the abuse. Additionally, he recognized to some degree pleasure in having power and control over his younger brother. In this sense, while I acknowledge that he reported experiencing fear and concerns of disobeying Ms. Vander Ark, I could not reliably substantiate his involvement as being a byproduct of suggestibility or coercion. So what this court is left to conclude is that Mr. Ferguson, the way I look at this is that Mr. Ferguson in these reports, and a lot of these, throughout the report, there's talk about how Mr. Ferguson bullied his brother when he was younger. There's a mention, his stepsister, who I think was allocated on behalf of his mother, or on behalf of Timothy at Ms. Vander Ark's sentencing. It says the stepsister, and this is before the police even really told her about exactly what had happened in here. It says the stepsister reportedly told the police that, quote, she doesn't know how involved Paul was in this situation, but he is the biggest bully she has ever met in her life, and he found genuine joy in tormenting Timothy whenever possible.
Judge, for clarification, I don't think that was Millie, that the stepsister.
So maybe I'm wrong. Okay, so perhaps I'm wrong about that. But this was someone who, without even knowing the full details, reported that. In one of the interviews, Mr. Ferguson indicated that he liked getting praised by Shanda and admitted he liked having control over Timothy. He reportedly admitted having power over somebody feels good. Later in the interview, I asked him whether he had felt ashamed at the time when he was abusing his brother, and he said, quote, no, he had not. I asked whether he had recognized his action as morally wrong at the time, and he again said, quote, no, he had not. He then volunteered that on one occasion, quote, I sent her a photo of how thin he was, and when I asked why he did this, he explained that I was worried. When asked when he was worried about Mr. Ferguson, Ferguson replied that he had been concerned for his health, observing that he was nothing but bones. I asked him whether he had, at the moment, thought that this abusive behavior was wrong, and he replied that, quote, that thought never even crossed my mind. Treatment plan back from July 22nd of 2012 indicates that, quote, client, meaning Mr. Ferguson, sometimes bullies his younger brother, the decedent, Timothy. The report also mentions cruelty to animals, stealing, abuse. His mother at the time, back in 2018, told staff at the clinic he's become bossy, telling his siblings what to do.
For Mr. Ferguson's part, reportedly, when commenting about his being irritable, he admits that this is due to his younger siblings not listening. He gets physically aggressive towards his younger siblings. He also tried to lock his younger brother, i.e. apparently a reference to the decedent, in the closet because his brother wouldn't listen to him. So the court read this and certainly looks at this as someone who is predisposed, I think was the ultimate conclusion, predisposed to abuse his brother. Specifically, the victim in this case, in a history of doing that. Now, I have no doubt in my mind that Mr. Ferguson is a result of years and years and years of physical neglect and abuse on behalf of his mother. No doubt in my mind that's borne out in this report. But the court is asked to essentially ignore the decisions or his behavior because of that, and to somehow say that we're going to minimize the damage and what he did in this case because of that. If the court started imposing that standard, I think we would be in real trouble, because every defendant that comes before this court has a horrible history, I would say. That's the reason they're here. People that have supportive parents and things go good for them typically don't come here. Now, that's not always the case, believe me. There's a lot of interventions. But everybody has a history. And what I was looking at is whether or not this is a product of his mother or his situation. And what I can conclude is that this is not. Mr. Ferguson is trying to shift blame from his mother, from him to his mother, to say that somehow, well, if it wasn't for her, I wouldn't have done this. Or she's the one that did this. At the trial, well, at her order. He kept saying it over and over and over again. This is just keep underscoring the point. And if that had been an isolated incident, if that had been one or two of these things, if that had been a punishment that he administered, maybe the court could accept that. But we have an individual who was in a household for 6 months, intentionally himself engaging in torture of another person. And he doesn't, well, I'm worried about my mom's going to say, clearly it's not borne out in these reports. He had the ability to disobey his mom. In fact, he was on the stand and almost boasted that, well, I gave him extra food. Well, weren't you worried about how your mom was going to be upset? I still gave him extra food. So what that tells me is that this has been a careful, manipulated story by Mr. Ferguson from the very beginning of this thing, that he's going to put the blame on his mom. I'm going to be manipulated. I have Asperger's syndrome. I have autism. I have Stockholm syndrome. There's mention of him saying, well, maybe I have Stockholm syndrome in here. No, this is an individual. What the truth of this is that we have two individuals that lack empathy, who lack emotion, and both of them, the triggering factor in this report, the triggering factor that caused this abuse was the removal of the husband, of stepdad. Once he was gone, these two individuals were free to torture somebody, and they did it. That's what they did. And I think Ms. Vander Ark did use Mr. Ferguson. I think that she knew from his history that he was predisposed to torment Timothy. I think that she knew that he would have no problem doing that. And Mr. Ferguson walked through that door and was happy to be the enforcer, was happy to do it, and continued to torture his brother over and over and over and over until he was a shell of a person, until he was dead, died from starvation, died from hypothermia. He had no fat on him, barely any muscle on him. And the whole time, just letting it happen. The report says it appears that the stepfather's presence in the home had prevented Paul and his mother from abusing the victim. Again, it wasn't anything to do, they were just holding him back, essentially. The overall opinion, which I think is important, is, in my opinion, although the defendant's participation in the abuse was in a part a function of his social milieu and living situation, these contextual factors were not a necessary condition for his participation. As previously noted, mental health records contain information to the effect that while they were still living with their father and stepmother, and reportedly had no contact with their mother, Mr. Ferguson's stepmother told the psychiatrist that he had become bossy, telling his sibling what to do, and the defendant himself that he would become irritable due to his younger siblings not listening. He gets physically aggressive, told his younger sibling. He also reports that he's gotten irritated with his siblings and has pushed them in retaliation. He's also tried to lock his younger brother, the decedent, in the closet because his brothers wouldn't listen to him. Consistent with this, Norton Shores Police Department documents indicate that Mr. Ferguson's stepsister told police, quote, he is the biggest bully she's ever met in her life, and he found genuine joy in tormenting Timothy whenever possible when they were living in the biological father's home. Notably, the defendant allegedly engaged in this abusive behavior despite there being any safety rules in place, and despite his father and stepmother disapproving of this behavior to such an extent that they removed him from their home once he turned 18 because of it. In my opinion, Paul Ferguson was predisposed to abuse his brother independent of his mother's present and active influence in his life. Nonetheless, in my opinion, Mr. Ferguson's involvement in repeated acts of abuse that amounted to physical and psychological torture over a period of months reflects a general lack of empathy for his brother and a lack of remorse for his actions. Concludes that, in my opinion, there is no reason to believe that Mr. Ferguson's conduct disorder has remitted or that his participation in the abuse of his brother was not an expression of a persistent pattern of antisocial conduct. The court is concerned that Mr. Ferguson will not get the help he needs in prison. I think he's one step away from becoming a psychopath like his mother. And the court is concerned that he represents a danger to the public. That if released, he would represent a significant danger to the public. The charge here is child abuse. And I don't think this charge or the sentencing guidelines take into adequate consideration of the long sustained torture in this case. As I indicated in Ms. Vander Ark's testimony, there was a long period of months of various punishments, including bread with hot sauce. There's hot sauce that apparently contains 2 of the hottest peppers that we have in the world. Wall sits for an individual who practically had no muscle left. Running up and down stairs, cleaning out a garage with no pants on, sleep deprivation in itself, putting alarms on him so he couldn't move or sleep, making him puke up food. There's bathroom timers, sleeping in the closet with a tarp down, which quite frankly might be considered animal abuse, but we have a human being here, making his hands over his head. And then at the end of his life, an 8-hour practically ice bath that killed him. So no, I don't think any of those things are adequately taken into consideration by the guidelines. And I don't think the guidelines, quite frankly, can even, these guidelines don't justify Mr. Ferguson's actions. Mr. Ferguson, I think you are a product of your environment. But I don't believe you that you're sorry. I don't. I don't think you have empathy. I don't think you have any emotion whatsoever. And that's what scares the court. It really scares me. I think you're sorry that you're here. I think you're sorry you got caught. I don't think you wanted Tim to die either, like your mother, because you would get caught and you wouldn't torture him anymore. And believe me, I've tried to sit here
and try to think, well, maybe Mr. Ferguson's not as bad as Mom. I think you're just as bad, if not worse. If not worse. Because you had a job. You could have, Mr. Johnson actually asked you, couldn't you have brought home a thing of food for him? You could have gone to a neighbor and said, hey, my mom's abusing him. You could have grabbed him and got him out of there. You could have done any number of things to stop this. And you chose not to. Your own brother. And this is where we're at. So, based on all that, the sentence of the court, you serve 30 years to 100 years, Michigan Department of Corrections. Credit for 592 days you've already served. Court's going to assess a $68 state cost, $130 crime victim assessment, no additional fines or costs. Mr. Ferguson, you have a right to file an appeal in this case if you're found innocent. If it's retained an attorney who will be appointed to a public expense. Request for the assistance of a lawyer must be made in 42 days from today's date. Clerk is handing you a form that you must complete. Return to the court in that 42 days if you wish to request the appointment of an attorney. Appeal or adjourned.
All right, so there you go. Paul is sentenced. I've got, while we wait, because we've got some time here, while Miss Vander Ark sorts herself out. So if you're joining us late, you don't know, she's claiming she has a headache. She was nauseous on the drive over. So they're taking a break to get her sorted out. So, in the meantime, let's go back to, we were kind of in the middle of watching this. This is her sentencing.
And
this is her daughter. So I want to watch this. I didn't see this.
The record, I think Miss Ferguson actually wrote a letter as well, I believe, and
I believe it's included, yes.
yeah, I have read that it's attached to the PSI, but she's certainly welcome to make a statement.
Good afternoon, ma'am. How are you?
I'm good. How are you?
Can you please state your name for the record?
Millie Joan Ferguson.
All right, you may proceed. Go ahead, Ms. Ferguson.
Thank you. I'm Millie. I'm Timothy's youngest older sister. I'm 2 years older than him. One of my earliest memories I have was being taken away from my parents by CPS. My two older brothers rode in a car ahead of us, and me and Timothy rode together in the second car. And in every picture we have as a family, Timothy was always right by my side. We were the two youngest, the two smallest. We were the two that sat in the middle in the backseat car rides with the two small car. The last two to get hand-me-downs, the two that never had to worry about not getting homework help from an older sibling. He was always 2 years behind me, so every time I got to the next level in school, that's how many years I had to wait for him to follow along. When I was in 8th grade, he was in 6th, and there was a student in my science class that started talking about him, trying to start rumors. I stood up right as class was starting, as people were quieting down, and I shouted at him to never talk about my little brother. People could say whatever they wanted about me, I didn't care, but not about him, and never about him, because I was his big sister. It was my job to protect him. I like to say I don't regret things in my life, that every mistake I've made has made me who I am today, but when Timothy died, I couldn't stop regretting. I regret not hugging him more and teasing him so much instead of telling him that I loved him every once in a while. I regret not putting aside my differences with Shanda and Paul just to check in on him. I regret not dancing with him the last time I saw him at our brother's wedding. These are the things that I can't remedy now. There's no fixing what's been done. No way to redo it all over again, and that's my regret. That I couldn't protect him when he needed me most. Timothy was so smart. He could take anything apart with any tools, or none at all. He had trouble focusing, but when he did, he was just as smart as the rest of his class. He made people angry, yes, but then he would look at you with those big baby blue eyes and you could never stay mad at him. It took me 6 months of therapy after he died to even properly feel the emotions of his death. And I'm still in therapy today. I've been trying so hard since he passed away just to try to let people know of him, let people know that he was loved, that there are people out there grieving for him. I'm here today for him because I was asked to speak for him, because I was given a victim impact statement for him instead of a witness one, because the victim of this crime can't speak for himself. I knew him his whole life. I held him the day he was born, and I continued to try to hold his hand as long as he was by my side, until he wasn't. I want the woman who killed my little brother to face the highest punishment possible. I want her detained for the rest of her life so she can't hurt anyone else. And I want the world to know that Timothy was wanted, if not by her, then by me. He was loved by me. Thank you.
Right. Thank you, Ms. Ferguson.
Well, there certainly is no love there with with her daughter, right? She's like, yeah, this woman deserves maximum punishment. All right, now here's her son. Here's one of her sons, right? We determined she has, you guys helped me figure that out. She has four sons and one daughter. So we just heard from said daughter. Now here's one of her 4 sons. And again, this is her sentencing. While we wait for her to get sorted out medically, she has a headache. She said she was nauseous, so they're trying to sort her out medically. That's why we're waiting. Welcome in, everybody. 10:40 here on the East Coast. We're waiting for Shanda Vander Ark to be medically cleared. She came to court. She said she had a headache. She was feeling nauseous. She was writing notes to her lawyer. So we're just waiting for her to be literally medically cleared. So the judge is saying, okay, let's get her some whatever medication she needs. So that's kind of where we are. So we're just playing some past testimony. This is from her sentencing. So this is one of her 4 sons. Well, we know Paul is in jail. Timothy obviously is the victim. And then she has a younger son, and now this is her oldest son.
Yeah, could you just please state your name for the record?
I go by Nolan. My full name is Eric Nolan Ferguson, Jr.
All right, go ahead, Mr. Ferguson.
I am Timothy's oldest brother, and unfortunately the oldest child of Shanda Vander Ark. I live with my wife 900 miles from here, and in July of 2022 I was working 60-hour work weeks trying to build a career when I received a phone call that I never thought I would get. My baby brother Timothy was gone. For 2 days I reeled with no explanation until I was informed that our own mother was in jail for his murder. Somehow, making an entirely unexpected and deeply awful situation worse. I thought that things were different than when I was younger. I thought my mother had changed for the better. Not one day has been easier since then. I've had to leave my career behind. My wife has to watch helplessly as I struggle, day in and day out, wondering how none of us knew what was going on. Wondering if I told Tim I loved him enough times for him to remember up until the very end. I have to wake up every day and pretend that I am who I was before Timothy died. I have to pretend to be Nolan so that my friends and coworkers and family won't worry about me more than they already do. I'm surrounded by people who love me and care about me, but not a single person besides my sisters who understand how hard it is. Timothy wasn't surrounded by people who loved him when he died, and if I had known that, nothing could have stopped me from rescuing him and holding him in my arms and telling him I love him, that his big brother's got him. just like I did the day he was born. But because of Shanda Vander Ark's actions, I instead got to cradle the bag of his ashes in my arms, just like I did the day he was born. In all my life, I only knew one thing that my little brother didn't like. He hated goodbyes. If he had to say goodbye to anyone, he would cry, and he would hold you, and he would say, "Don't go." But now I'm the one crying, but I never got to say goodbye. I will always love Timothy like I always have, and it kills me to think about it. But I know he loved even his abuser and killer up until the very end, because unlike me, that's all he was capable of: love. I, on the contrary, want to stand here and express the anger and hatred that I feel, but if I'm honest, all that's just a mask, a bandage I try to put over the hole in my heart that was reserved for Timothy, but is now just filled with pain and remorse for every hug, high five, and I loved you that I might have missed in the time that I had with my sweet baby brother. So now I turn to the justice system in hopes that in addition to serving the maximum penalty, that there will be no appeals or second chances. If I can't have my brother back, she shouldn't have her freedom back. And lastly, I want everyone to know that to those who knew him, even that wouldn't feel like justice. Because the life of one sweet little blue-eyed boy is not equivalent to that of a murderer.
Thank you, Mr. Ferguson.
So Colleen's asking the screen behind him, the defense table. It looked like it was somebody on Zoom. It looked like to me that looked like somebody on Zoom. So that screen, that's like he walks up. Somebody on Zoom. So you're asking about that? Is that what you're asking about? I don't know. I don't know what that is. I have no idea who that is. But there may be somebody appearing by Zoom. Yeah, I really don't know. Yeah, it looks like somebody on Zoom, right? Amy and Jenny. Yeah, I can only guess. Yeah, somebody on Zoom of some. Yeah. Yeah, curious. I really don't know. But if they were doing Zoom, you would think there'd be more people watching, but I don't know. Yeah. All right. Let's watch her testimony. I mean, while we're sitting here, no. Let's not get to her testimony. I want to watch opening statements. I want to hear opening statements. I want to hear what the state said she did. I mean, we kind of know what she did. You guys know what she did. You guys know more about it than I do. I want to hear what the state has to say. All right, I want to hear what the state has to say. All right, so this is state opening statements. Prosecution opening statements.
You want the TV angle toward?
No, not that yet. No, thank you.
Good enough.
Good morning, ladies and gentlemen. Once again, on behalf of the people of the state of Michigan, I want to thank you for your time and attention to these matters. We certainly had some lighthearted moments yesterday during the jury selection process, and there's nothing wrong with that. But as Mr. Johnson and I repeatedly told you yesterday, and this is not in any way an overstatement of this, the facts and circumstances here are just simply horrific. I wish that I could spare you from some of the details in this case, but I cannot. Quite simply, it is the position of the people of the state of Michigan that Shanda Vander Ark committed the crime of first-degree felony murder when, during the course of physical and mental abuse in the first degree of her child, Timothy Ferguson died. As we referenced many times yesterday, unfortunately, as part of this process, you will see some very graphic photographs, images that will not easily leave your mind. But I don't want you to focus on just those photographs, as I repeatedly told you yesterday. I want you to look at the entire picture here. I will tell you this, the entire picture is just as horrific. The average 15-year-old male weighs 132 pounds. and is 68 inches tall. At the time of his death, Timothy Ferguson was right on that average height, 68 inches tall. At the time of his death, Timothy Ferguson weighed 69 pounds. How does this happen? How does a 15-year-old child die as a result of malnutrition? How is a 15-year-old child 63 pounds under the average weight? How is a 15-year-old child in literally the 0th percentile for weight? How? The how of this begins to unfold on July 6th of 2022 when police officers from the Norton Shores Police Department are dispatched to 4788 Marshall Road in Norton Shores. The first officer on scene is there. ProMed's already on scene, and they've already found Timothy Ferguson deceased in the basement level of that home. You're going to see photographs of that home. It's a bi-level home, and Timothy Ferguson is in the basement of that home. By the time the officer arrives, Timothy Ferguson is deceased and has been deceased for some time. It's immediately obvious to ProMed, just as it is to Officer Stefanich, who you will hear from this morning, that Timothy Ferguson is severely malnourished. Now, there's another layer of mystery that is discovered the next day as it relates to the cause of death of Timothy Ferguson. And you will hear from the medical examiner that in addition to the severe malnourishment that caused his death, Timothy Ferguson also showed signs of hypothermia. How does a 15-year-old child in Michigan in July have hypothermia? The pieces of that puzzle start to unfold as the police investigation does. Officer Stefanich begins to notice, in addition to the shocking image of Timothy Ferguson, deceased, other things unusual in the home. There's leg cuffs in the basement. There's cameras everywhere. There's hot sauce in the bathroom. Upstairs in the upper level of the home, there's locks on the refrigerator and the freezer. More cameras, motion sensors, alarms, everywhere in the house. And in the basement, as if part of some demented version of Harry Potter, there's a small closet, again with an alarm on the door. Inside that closet, a blue tarp just laying on the floor and a small box. That room, as officers later come to learn, is called the small room. That was Timothy Ferguson's bedroom. That's where he was forced to sleep. The leg cuffs, also for Timothy Ferguson. The cameras, also for Timothy Ferguson, to watch his every movement. His every movement monitored by his mother on those cameras. The bathroom camera. Who puts a camera in a bathroom? The bathroom camera is literally a motion tracking camera, and the officer notices as soon as he walks into the bathroom that the camera starts to follow his motion. Again, hot sauce in the bathroom. Why is there hot sauce in the bathroom? These are all questions at the time the police officers have, but they have no explanation for most of it. All they know is that Timothy Ferguson died as a result of malnutrition. As is obvious to anybody that would just see him, look at him. So Officer Stefanich starts to ask some questions. And Ms. Vander Ark says, well, he's been on a hunger strike for the last couple of weeks. He hasn't been eating, and I noticed last night he wasn't eating really good, so I made him some toast with some peanut butter, or some butter on it, and I made him eat it, and then he went to bed. And then more detectives become involved in the investigation. And more statements coming out from Ms. Vander Ark about some of the unusual things in the home. The leg cuffs. Oh, those are Paul Ferguson. Paul Ferguson is the older boy that lives in the house. He's 19 at the time. And you're going to hear from Paul Ferguson. And I'm just going to tell you right now, you're not going to like Paul Ferguson. I don't like Paul Ferguson. Paul Ferguson was a contributing factor to the death of his brother. What you will come to learn is that what Paul Ferguson was the strong arm for the defendant. When she wanted a punishment inflicted upon Timothy, she used Paul to do it. And Paul did it. And he will tell you that he did those things. And he will tell you he is remorseful about those things. As he should be. Because the mental and physical abuse that those two individuals inflicted upon Timothy Ferguson over the course of multiple months, from February of 2022 until the time of his death in July, caused his death. For all intents and purposes, Timothy Ferguson was a prisoner in his own home. He never went to a doctor. He never went to school. The only time he was allowed to leave the house was if he was being punished and he had to run up and down the stairs in the backyard where nobody could see him, or walk the dog in the backyard, again, where nobody could see him. And you don't have to take my word for it. You will hear in the text messages between Paul Ferguson and Shanda Vander Ark the extent of the horrors they inflicted upon Timothy. You will hear about his every movement being monitored by motion sensors and alarms on his body, multiple alarms on his body. Cameras watching his every move, making sure he did not go upstairs without permission, making sure he did not go to the bathroom without permission. And when he went to the bathroom, he got 1 minute if he had to pee, and 2 minutes if he had to poop. Some of you might already be saying to yourself, this sounds too incredible to be true. Again, you don't have to take my word for it. You will hear the text messages. You will see right there in print, right there before your very eyes, everything that I'm telling you. His access to food denied. Locks on the freezer. Locks on the refrigerator. Alarm on the pantry door. Alarms on the door to the small room where he was forced to sleep. Now, interestingly, when we talk about that alarm on the small room, you're going to see the photographs of that alarm. When the police are there the first day, they take photographs of the scene. And as the investigation progresses, they go back the next day. Strangely, that alarm has been removed. The police get the text messages and start to go through the text messages, and a broader picture begins to emerge of what happened to Timothy, especially in those final hours leading up to his death, in the early morning hours of July 6th. And what they find is just as shocking as the fact that Timothy died as a result of malnutrition.
Mr. Ambrose, your client.
All right, we've got some action here, guys. Give me a moment.
All right, I know there's some.
The MDOC.
I'm going to rewind it, so hang on.
Would dispense it, since my understanding.
Hang on.
She's not.
Your client, 23.
Okay.
All right, we're back in the record in file 23110FC. People versus Shanda Vander Ark. All right. Mr. Ambrose, did your client, was she able to get some medication or no?
No, not yet.
All right. I know there's some bureaucracy stuff that goes on between the deal and.
The MDOC is the one that would dispense it, since my understanding, because she's not in Muskegon County custody, that it have to go through MDOC. So I did send an email to the person in charge of the MDOC, who would be the person that could authorize at least some medication.
How is her headache now?
Not good. I mean,
all right. All right, I did get a copy of the medical records. I'm assuming that we don't want to make those a part of the record, at least certainly not an open part of the record. I guess, how do you guys want to proceed with that? I can make them a confidential part of the record.
I can stipulate to any sort of protective order that the defense would want.
Mr. Ambrose is...
That's fine.
Okay, so I'll make them part of the record. We'll call it the court's exhibit number 1. It'll be a confidential record. The court did have a chance to review those records. It looks like on the 22nd, without going into all the details, looks like on the 22nd, Ms. Vander Ark complained of that she felt like she was going to pass out. I don't think there's any indication in these records that she did in fact pass out. There was some concern with some thyroid issues when she was eating apples, I guess, and they basically told her, don't eat apples. That's what's in the records. So there's nothing in these records about her actually losing consciousness. She reported that she was going to pass out. There's also indication that she asked for some Dramamine for the trip to Muskegon because she typically gets car sickness. So that's kind of in line with the testimony that she felt sick on the way here, but she at least indicated that she gets car sick. So unless I'm missing something, it sounds like they sent her because there was no concern. So based on the records and what we've already done here, I think she's competent, and we're going to move forward today. I am concerned that she reported losing consciousness when a medical person indicates that she complained of feeling like she was losing consciousness, and that she's now kind of amplified for whatever reason, I don't know. But I am concerned about that, the fact that she misrepresented that to her attorney, potentially, that she actually lost consciousness, because there's no record of that in the prison. So anyway, anything else before we move on, Mr. Ambrose?
well, the only way that, she would have to report to the medical personnel that she actually did lose consciousness. So
well, I mean, she okay, I get it, but the quote is, quote, I felt like I was going to pass out. I have tremors that are severe. That's what she reported on the visit November 22nd, 2025 at 6:45. And she was treated. She says the administrative note was that she was advised on site that the above patient came to the clinic concerned of dizziness and a tingling throat. The tingling throat was transient and only when she ate apples. And it says the RN advised patient had a reddened throat, no swelling or lymph node enlargement noted. And eventually the treatment is, it says she did palpate in a large thyroid. However, the patient is, I don't want to get into that. Says RN still had concerns about patient's fall risk. The RN exam otherwise unremarkable. RN gave the patient detail prior to calling. I advised RN to tell the patient to stop eating apples. Other than that, I did not have orders for this patient. So that's what happened on the 22nd, at least according to the note. Like I said, I don't know what happened, but these are medical records by individuals that I don't know if they'd have a reason to lie, quite frankly, if they're making a medical record. So based on that, I don't see a serious medical issue that is to the concern of the court. So anything else, Mr. Ambrose, on that? I mean, she can testify if she wants about what she's going through. That's fine, but if the request is for an adjournment because of a medical issue, I don't see it. So.
When I testify? Yes, please. I'm
not. Listen, I'm not going to delay this anymore. This is, in my opinion, Mr. Ambrose. She's misrepresented and through you to the court that she passed out. She did not pass out. So I'm moving on. I think this is gamesmanship on her part, and it's now 11 o'clock on a hearing that we were supposed to start at 9 o'clock. The court's been very patient with this, and we need to go. So,
Okay.
Anything else?
No.
Ms. Bloomquist. All right. So, Mr. Ambrose, this is your hearing.
Yeah.
You can call any opening statements on either side, or do you want to just get straight into witnesses?
We can go straight into witness.
All right. You can call your first witness.
Johnson.
All right, Mr. Johnson, if you want to come on up front here, sir. Good morning.
Good morning.
All right, would you raise your right hand to be sworn?
Yes, sir.
This matter now pending. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, and put your hand down and grab a seat. Please state your name for the record, spelling your first name and last name.
My name is Fred Johnson, Fredjohnson.
All right. Mr. Ambrose, you're welcome to stay at the table or the podium, whichever you prefer. So you can stay standing, stay sitting. It's up to you, okay?
Thank you. Mr. Johnson, you represented Shanda Vander Ark, is that correct?
That is correct.
Okay, and do you recall, you're an attorney?
Yes, sir.
Can you tell us when you became an attorney?
1984.
You know, and I apologize, Your Honor, before we start. Ms. Vander Ark, Mr. Johnson may be getting into some confidential information. You understand that?
Yes, sir.
And you understand that by going forward with this type of hearing, that he's going to relay some confidences.
Yes.
Are you okay with that?
Yes, sir.
Do you have any questions regarding that?
No, sir.
Okay. With that disclosure, Your Honor, I'm going to proceed with...
Okay. Anything else we should put on the record regarding that you want, Ms. Bloomquist? Okay. All right. Good enough.
What year did you become an attorney?
1984.
Okay. And where'd you go to law school?
Thomas M. Cooley.
And so from 1984, have you always practiced criminal law?
I have always practiced criminal law, yes.
Okay. And has your license, have you continuously been an attorney ever since 1984?
No, sir. My license was suspended last year for 6 months.
And what was that? So it was suspended last year for 6. What was the reason why it was suspended?
Violation of confidentiality, conflict of interest rules.
Okay. And that was while you were a public defender?
Yes.
And when you represented Ms. Vander Ark, you were a public defender. Is that true as well?
Yes.
And the initial allegation that was lodged against you, when does that go back to?
Oh, gosh, that was... I couldn't tell the year. 5 years ago, perhaps 6.
And when was the complaint issued against you?
2024 is my guess.
Okay. And
2023, perhaps.
Did you admit to the grievance?
Yes, I did.
And what did you admit to?
I admitted that I had received information from one client while representing another client, and the person who the information I received was the victim in that case, in the second client's case.
And again, this was while you were the public defender?
Yes, sir.
When did you take on that role?
2013.
And
September.
What did your office consist of?
In 2013?
Throughout the years.
It grew over the years.
Okay.
We started, I think we at 13, and by the time I left, we were in our 20s, maybe 25, 26.
Okay.
And that includes staff as well.
So you mentioned that you admitted to the allegations within the grievance.
Yes, sir.
And what did you have to do as a result of your suspension?
I was suspended for 6 months, so I could not practice law. There's a fine and costs.
Were you required to take any type of classes?
Was I required to? No, I didn't. I was not required to. I did, but I was not required to.
What type of classes did you take?
On ethics, conflict of interest.
Okay. And did you testify at any of these hearings?
Which hearings? The ethical issues hearings?
Yes.
Yeah. I don't know if it was testimony or not. I made a sworn statement at the time of my initial interview, and I spoke to the state bar, and I think that was under oath as well. So that both might be considered testimony.
Okay. And part of your disclosures were that you're more or less overworked. Is that accurate?
Was I overworked? I think I was.
And would you disagree with, I was working too long, I was working too many cases, too much stuff, too many irons in the fire? Is that something that you may have said?
Yes, sir.
Any disagreement about that?
No, sir.
Also, basically, when I was a public defender, I was working on a conveyor belt system, and the problem that came up on the belt next is the one I tackled and tried to keep the other ones juggling until I could fix them as well. Does that sound like something you might have said?
Yes, sir.
Now, this case with regard to Ms. Vander Ark, do you recall when you initially, how is the assignment system conducted in Muskegon County?
You mean back then or now?
When you were assigned.
When I was public defenders?
Yes.
Okay. The attorneys are assigned to judges, and whatever case the judge received, that attorney assigned to that judge will receive that particular assignment. Normally that was the situation, unless something came up and we'd have to change assignment for whatever purpose might have occurred.
Is there a private bar that receives assignments as well, or is it just everything that every indigent client goes through the public defender's office?
Things have changed over the year. Things have changed over the years. Currently, all the indigent individuals go through the public defender's office. There is a private bar, however. Are there assignments to the private bar? On occasion there are, and there were.
Upon receiving the assignment, do you recall when you would have first talked to Ms. Vander Ark?
I would assume it was before the preliminary examination, but I don't have a specific recollection of any particular dates.
At any point in time at the preliminary examination, with your initial conversation with Ms. Vander Ark, did she ever admit to any type of guilt?
No, sir.
All right. Now, she contended that she was innocent throughout this case, isn't that right?
Yes, sir.
She testified, right?
Yes, she did.
She never admitted to any type of wrongdoing that caused the death of her son.
That is correct.
Now, while you were assigned to the case, did you have Ms. Vander Ark see a professional with regard to competency or criminal responsibility?
I had Ms. Vander Ark see several professionals, 2 doctors, and we employ social workers on our staff.
With regard to, do you recall having Ms. Vander Ark seen by Colin King, Dr. Colin King?
I do recall that.
And in Mr. King's report, did he do a report?
He did.
And do you recall what the results of that report were?
I don't recall the specific results. I recall the conversations we had in regards to that report.
As part of his conclusions, would you agree or disagree that he mentioned that Ms. Vander Ark continues to insist she did nothing wrong and was not convinced that her actions and instructions caused the death of her son?
I don't recall that specifically. If you have the report, it might refresh my recollection, but I don't argue with that statement. It sounds, generally speaking, as what I recall.
May I approach the witness? You may.
Here, stand up. Yes, sir.
And it's an accurate statement that she had stated that to this doctor that she felt that she did nothing wrong. Is that correct?
Yes, sir.
And you went to trial on that basis, right?
We went to trial because she was charged, sir.
And she proclaimed her innocence, right?
Even had she not proclaimed her innocence, we would have gone to trial, and she's charged with first-degree murder. But yes, she proclaimed her innocence from beginning to end, and we tried the matter.
Were there any offers made to Ms. Vander Ark?
None that I can recall, Your Honor. Sir.
Now, Ms. Vander Ark testified at trial, right?
Correct.
And she again proclaimed her innocence to the charges, right?
That is correct.
And there was an incident on the day of her testimony where she had a physical reaction to seeing a photograph of her son.
I believe that was if we're talking about the situation where she turned and there was a trash can there, and she appeared to I don't know if she actually did vomit, but she had, the body language was indicating that's what was going on. I was sitting in the chair over there where the prosecutor is.
And during her cross-examination was. You described the cross-examination for us.
Aggressive and effective.
Okay, aggressive and effective. And did you see Ms. Vander Ark after court that day?
I don't believe I went out to the jail to see her after court that day, no.
Okay, did you go into lockup with her after court?
I can't honestly tell you that.
All right. The next day, can you tell us what happens?
And if my recollections are correct, the next day court was resumed, and my client, Ms. Vander Ark, was unable to attend. She was unable to come to the hearing, as I recall.
And you reported that to the court, right?
Yes, sir.
And you stated to the court that she had some competency issues at that point. Is that correct?
Some competency?
That she wasn't able to proceed.
Yes, and yes, sir.
May I approach you, Daniel? And this is I'm showing you a transcript of December 15th, 2023. It's on page 3. If you can just read that portion.
Yes, sir.
And so you indicated to the court that she wasn't competent to proceed, is that right?
That is the word I use, sir.
Okay. And describe to us what she was going through.
She was, when I went to visit her, she was curled up in a ball on the floor. She was crying. She was upset. She expressed that she couldn't return to court. She expressed that she was upset, that she was stressed, that she was experiencing, and I'm sorry, I forget the word. She was experiencing a period of where she's so emotional she can't function intellectually.
And based upon that, you reported that to the court?
Yes, sir.
And you also, do you recall reporting to the court as well as that if we waited until, or adjourned the matter until Monday, Tuesday, or Wednesday of the following week, we'd be in the same situation?
I don't recall, but I'm not arguing with that. I assume you have transcripts there. I don't recall saying that, but...
If you look on page 4...
Which paragraph, sir?
The second full paragraph.
Okay.
Starting with the word 1.
Okay.
And you agree that you told the court we couldn't guarantee to the court that as of Monday or Tuesday or even Wednesday of next week we'd be in any different situation than we are right now.
That is what I said.
And was that an accurate assessment?
That was my assessment at the time, yes, sir.
Do you... Okay, so... One of the things that you argued to the, or suggested to the jury was that Ms. Vander Ark was guilty of manslaughter. Is that right?
That she was guilty of manslaughter?
Yes.
I don't know if I used that term. I don't recall arguing on the manslaughter issue. Can you tell me which page?
Yes. I have this broken up, but it's on page 84.
Okay. Do I have it?
Yes. Here we go.
Okay. And whereabouts on 84, counsel?
It's actually on the very last page, page 80.
All right.
First full paragraph. and you told the jury, these people, and I'm assuming you meant Paul as well, these people committed manslaughter. That's what they did.
Yes, sir.
They caused the boy's death. That's
Yes,
what you
sir.
said. Now, Ms. Vander Ark never gave you consent to say that she was guilty of anything, did she?
No, sir.
And so you kind of took it upon yourself to make that argument to the jury.
Yes, sir.
I have nothing further.
Morning, Mr. Johnson. How are you?
I'm well, thank you.
So I'm just going to go back a little bit more into your experience. How many years have you been a practicing attorney?
41 this year.
And how many years of that as the chief public defender for Muskegon County?
2013 to 2024, so 11 years.
Is it fair to say in your role as the chief public defender, you would take some of the more severe cases that the county has seen?
Yes, sir.
Okay.
Yes, ma'am. My apologies. I'm on the roll here.
Now, just sort of getting into some of the comments that were brought out from your sworn statement or things like that, there's discussions about your workload. Do you recall that? And maybe feeling like you had a conveyor belt system.
Yes, ma'am.
Did a case like this fall into the same category of cases you were discussing in that?
No, the cases like this get the spotlight. They come out of the group of a pack, and we place not only my efforts but the social workers and other attorneys on staff. We all work on cases of this magnitude.
Okay. So, although there's testimony by you to the effect of being overworked and that impacting some of your cases, is that an accurate sort of representation of what's said?
It certainly impacted the one where I saw that information and I shouldn't have seen it. It impacted there. That's what I think has happened. So. But I'm sorry. Go ahead.
No, and that's okay. And just to be very clear, the case for which you had your suspension had absolutely nothing to do with this case, correct?
That's correct.
No witnesses between, Paul and Ms. Vander Ark. That wasn't the conflict at issue.
That's correct.
Okay, it was a wholly unrelated matter.
Yes, ma'am.
And while we're on that topic, did you have to sit in that exact same witness chair in a Ginther hearing on that case as well?
Yes, ma'am.
Okay. And you testified about the allegations and the conflict that was alleged?
Yes, ma'am.
So getting back into your prep on this case specifically, let's walk the court through your preparation for trial. Let's start with prelim.
Okay.
Walk us through your preparation for preliminary examination on this case.
Well, I assume all lawyers do. You receive information called discovery, and you pore over it. You go out and see your client, and you talk to your client about what's going on and what her impressions are. You come back and you go over it again. You bring in other attorneys to take a look at issues. You run issues by them, see if they have any similar experiences or any pointers that they may want to bring to bear. You bring another attorney in, usually a younger attorney in, to sit to watch the whole process. We also employed interns here, so the beauty of interns is, whereas I may have multiple cases, they only have the one, and they pore over the documents and the materials, and if there's anything in there that they see, then they can bring it to my attention. But it's a fallback situation, so we can bring other eyes on it. And there was no different than here, Ms. Vander Ark. We did all these things. We worked dozens of hours just for the preliminary examinations, and we were ready to go.
So it sounds like you created a team, so to speak, for Ms. Vander Ark.
Yes, ma'am.
How many people would you say were on that team?
Over time, coming and going, over time, from the time we got the case to the time we ended, maybe 4 lawyers, an investigator, 2 or 3
social workers, so we're up to 9, and a half a dozen interns, so about 15, 16, something around that line.
So 15 or 16 people working on her case specifically?
Over the course of time, yes.
Okay. And as part of your preparation for trial, now let's shift to preparation for trial. You talked about hours for preliminary examination. Could you describe to the court your preparation for trial?
Well, at this point, we've had time, a year, to look at this thing. We've brought in experts to examine my client. We've gone out to the scene of the crime and taken photographs and walked around, got the feel of the place. We've talked to multiple folks who we were considering experts, but we ultimately didn't hire. We spoke to outside social workers to see if any of them had come across any episodes along the similar line. We even saw an article in People magazine about a woman who thrown her kids out the window and then jumped herself. And quite frankly, it was eerily similar. And quite frankly, I'm still convinced there's something to do with my client's conduct. But it was hundreds of hours by then. And I'll put in a couple hundred hours myself on it, and then you add in what everybody else is doing. It's a lot of time. It's a lot of effort. And I've told her I think if she had to hire, she'd spend $1 million on what we did for her in terms of trying to prepare and defend her in this case.
So just so I'm clear, you yourself dedicated hundreds of hours personally to this case?
Yes, ma'am. It was either I'm reading something or I'm talking to somebody. I'm looking for this needle in the haystack. I believe then, and I believe now, there's something wrong with my client, and that there's somebody out there who would be able to tell me what it was. And I still believe that to this day.
So I want to dive a little bit deeper. You said that you sought out experts, correct?
Yes, ma'am.
And were some of your experts from the Center for Forensic Psychiatry? The sort of state-run?
We use the appellate defender has a website, and they have a listing of witnesses, expert witnesses that other lawyers have used, and we use their list in determining which ones to approach. We also use here from the other lawyers in the office. Have you used anyone in these circumstances? Do you know of anyone? And those are the lists we use.
Okay. And so I know the record will reflect this, but I want to ask you, do you recall having a criminal responsibility report done for Ms. Vander Ark?
Yes, Dr. Watson.
And do you recall also having a criminal competency report done as well?
Yes, ma'am.
And now those were ones that I believe were filed with the court, correct?
Yes, ma'am.
Were there reports that you or examinations that were done and reports that were drafted that were not filed with the court on Ms. Vander Ark's behalf?
I don't know if we filed Dr. King's report or not. I don't think we did.
Okay. And did you also get a report from a George Watson Jr.?
Yes.
Okay. And to your knowledge, was that ever provided to any, to the court or to the parties?
To my recollection, no.
Okay. Is it fair to say that you did a lot of investigation into experts who could testify about her mental state?
I think that is fair.
Why didn't you present those experts?
The conclusions the experts provided would have been supportive of a verdict of guilty of murder. Their positions were uniformly and enthusiastically negative towards my clients. They would have been prosecution witnesses had we presented their findings.
So you intentionally did not call these experts?
That is correct. We intentionally did not call them.
And that choice was made after a thorough investigation of their opinions, correct? Or I guess explain the investigation that went into that determination.
Dr. King, for instance, when I spoke to him, his response was, "She's a monster." his response was, she's the worst thing he'd ever seen. And he's a man who testified for mass murders. I did not want to bring his testimony in. Dr. King simply said that she was competent at the time and she was competent for trial, and he had no, and that's not what I wanted the jury to hear. I want the jury to hear that there's something wrong with her.
So let's get into, and I hate to zoom out here from these details, but what was your overall strategy?
The overall strategy was to attack the issue of premeditation, that my client premeditated when she caused the death of this young man. Our strategy was to demonstrate that through especially her text messages that she was, for whatever reason, unaware that her son was suffering and was close to death. And we tried, especially with her text messaging at the time, to demonstrate that that was the case.
And I know you previously said you were looking for a needle in a haystack for something in your defense, correct?
We were looking for the cause. If you understand the facts involved in this case, this young man was her son. This young man, she could have refused him. She could have refused even to take him into her home. She brought him into her home to care for him. This young man was killed in the most brutal, heinous way that you can imagine, slowly starving him to death. And it probably is just because that's the way I'm built. I just can't believe that a healthy person would have done the things that she did. I don't believe it to this day.
Now, the realities of this case and the nature of it is something you have to factor in your preparation, correct?
Yes, ma'am.
And you did, in fact, do that?
Yes, ma'am. The evidence? Yes.
And now you've talked about these hundreds of hours. Have you also, in preparation for this trial, did you engage in witness preparation?
Of my client?
Of anybody?
Yes, we talked to my client about her role and how we were going to decide once we got there if she's going to testify and the sorts of things she might be asked and the sorts of things that we'd be asking of her. Our only other witnesses would have been the experts had they been called. And so there wasn't anyone, or the social workers. And since we didn't call any of those folks, it wasn't necessary to prep any other witnesses for testimony.
And additionally, in preparation, did you evaluate filing motions to suppress or other sort of pretrial motions on this case?
Certainly. And that was the value of the groupthink. You have several lawyers and you're asking them, and an investigator, what about this issue? What about that issue? Should we file a motion on it? Should we attempt to take you to the Court of Appeals? We lose that sort of thing. All those issues were discussed.
Did you also prepare for your voir dire in this case?
Yes, I did.
Okay. Are you aware there's an allegation that you did not prepare for voir dire in this case?
Yes.
Okay, and in preparation for today's hearing, did you provide to me some documentation from your file regarding your voir dire?
I did.
Okay. Your Honor, would you like the people to be numbers or letters given today's proceeding?
Let's do numbers. We'll stick with consistency, unless someone's pre-marked exhibits, but we'll do numbers.
Okay, I'm going to be showing, may I approach?
You may.
All right, I'm showing the witness what's been marked as People's Proposed Exhibit 1. Could you identify what this is for the record?
Yes, this is my standard voir dire sheet, in which 4 pages of questions that I may or may not be asking depending on the nature of the case, but certain things that I want to make sure I cover and ask the juror or potential juror before they're seated.
Okay. Do you recall if you used this preparatory document in your trial?
Yes, I did.
Okay. And I know this is a blank version, but did you take notes on it during the trial? Or?
Yes, I did.
Okay. Your Honor, at this point in time, I'd move for the admission of People's Exhibit 1.
Mr. Ambrose?
I'm sorry.
There's been moving for admission.
I have
Exhibit
no
1.
objection to this.
Okay. All right, so Exhibit 1 is
You
admitted
can just leave that on.
without objection.
What did you do to prepare for voir dire? Was it all contained in this document, or what else did you do?
No, ma'am. The day before, a couple days before a jury trial, the list of potential jurors are made available to the parties. We got that list, and there's some information. It used to be better when it was handwritten, but now the computer stuff is not as helpful. But there is information, and we, and I say myself and the interns go over this information to discuss potential jurors. We're looking for folks that we want to keep on the jury and folks we don't want on there, and so we're going over these things, and we're asking questions back and forth. Do you know these people? Have you met these people? Are these people, witness? Are they friendly to us? Would they be hostile to us? And we're going over that list. And so we've got notes. When we come into court, we have notes on the witness list that they gave us as to individuals we may not be calling. We may not wish to sit on the jury. A police officer. If there's a police officer, we're probably going to ask him to be removed or her to be removed. So we go over that. Then when we get to when we prepare, we're looking at which of these questions are important to us and which ones are not. The way voir dire works, as you know, they're asked, did you hear all the questions and would you answer any different? So you can't ask the same questions over and over. So what I try to do during my voir dire is specifically save out some questions so that every time I take somebody out, I have new questions for them. The whole panel hears them, but they're new questions, and they kind of help keep the interest of the rest of the panel. So that is part of the voir dire preparation. The reality with voir dire is, if you pick a bad jury, the case is over. You're done. You've got to emphasize that part, because if the jury's not listening to you, it doesn't matter how brilliant you are afterwards. The voir dire has to be effective for your client. So we put a lot of emphasis on it.
And you specifically did in this case?
I specifically did in this case.
Now, is also part of your voir dire come from experience?
Yes, ma'am.
And could you give a rough estimate before this trial how many jury trials you have conducted? Misdemeanor,
misdemeanor and felony, maybe 2 or 3 a year. Felonies, and back when before I became a public defender, 10 or 15 misdemeanor cases, literally a couple hundred. I don't know. I've lost track a long time ago.
You don't keep a sheet with them or something anymore?
At least 10, 15 a year for 30 years. That's all.
Okay, thank you. But you have vast experience in selecting a jury, correct?
I've done it many, many times.
And is part of selecting a jury knowing potential jurors out in the gallery that might be called up if you excuse somebody?
Yes, ma'am.
And I guess, do you see your obligation as a defense attorney to make sure you use every preempt, or to make sure you get the best jurors seated in those seats?
I want the best panel, and I will. I tell my folks, the young folks, it's not how many questions you ask the right questions. You don't need to ask 100 questions. So there are occasions when my voir dire may be brief, but hopefully it's effective. And I'm talking, and as Judge Kacel will tell you, I talk loud. Everyone in the courtroom can hear me when I'm doing my voir dire. I speak to the people out the back as well as in the panel. So yes, I'm aware of the panel here, but I'm also aware of who's sitting out there in the jury. Sometimes taking a person off the jury doesn't mean you're going to replace them with someone better. That's the Detroit Lions philosophy. Just because you replace somebody doesn't mean they're going to be better. Sometimes once you got the best you have, you stop talking.
Did you feel like you had a good panel in this case when you concluded voir dire?
Every lawyer says, I want a fair jury. We don't. We want a jury that's going to do what we want. I want a jury that's going to say not guilty. I got a jury as close to that as I was going to get from this panel.
So I'd like to shift a little bit and move into your interactions with the defendant. Do you recall, and it can be approximate, how many times you met with her personally?
Gracious, no. I couldn't meet with her. Well, okay, me personally. Gosh. No, it was, I tried to get her at least every other month, so if we had a year, maybe 6 times, maybe. And then during trial, and then after trial, and then are you counting the time after trial when I went to Jackson to meet with her?
Well, let's
Or just before trial?
let's say before trial.
Okay.
But then I'll get into the Jackson.
Half dozen, somewhere between 6 and 10, something like that.
And that was while she was lodged at the Muskegon County Jail?
That is correct.
Okay. How did those meetings go? What was the general atmosphere?
The meetings went very well, notwithstanding what she was convicted of. Ms. Vander Ark was a wonderful client. She was a client from heaven. We talked. Her conversations were on point. She used time well. She didn't keep me after the point of the visit was over. She asked good questions. She responded well. We had and we have a wonderful attorney-client relationship.
And so it sounds like she was a cooperative client.
Oh, absolutely, always.
And she had, would you say, above average understanding of the proceedings and what was coming with the trial?
She's a lawyer. She went to law school. She graduated from law school. She missed one question on her bar examination. She clerked for 2 judges. She must have sat in on a dozen felony murder cases, sat in and watched them. So she had as much experience with the law as somebody who has never practiced could possibly have. She was, and our interactions were tailored towards that. It's not one cookie cutter for every client. Her situation was different. She could understand and put together the facts and circumstances in a way that a layperson couldn't do, and that was very effective for her and and I appreciated it.
And in those discussions with her, is it fair to say you discussed trial strategy with her?
Yes.
Okay, what was that trial strategy?
The trial strategy initially, and hopefully when we began, was to find that there was no intention, there was no premeditation, and that there is something mentally wrong with the person that committed this offense. Quite frankly, as I would tell my folks when I first met her, and in the first 6-7 months we worked on this, I would tell them there must be somebody else living in that head along with her, because the person I knew and the person who did these things, they just didn't matter. So our hope was to find somebody who could put a finger. This is what she has. This is what's wrong with her. When that proved to be didn't bear fruit, we moved to, okay, when did she perform? When did she create the intention to even injure her son? Because our argument was she never formed it.
Did you discuss manslaughter with her?
Yes, manslaughter, murder in the second degree, all the homicide crimes we discussed, each and every one of them.
And you read portions of your closing argument.
Yes, ma'am.
And did you discuss with her about conceding manslaughter in your closing?
I don't remember that.
Okay. Why did you concede manslaughter?
The volume of evidence and the type of evidence was massive. And if you look at a jury and you tell them that nothing's wrong when it's clear to even somebody hasn't been attention that something wrong has happened, you lose them. And when you lose credibility with the jury, they never listen to what you have to say after that. Quite frankly, I was hoping for murder too. I told them manslaughter because that would give them the space to move up but I was hoping that they would see me as a fair dealer, as an honest person who looked them in the eye and told them this is what's going on, and I'm not going to try to lie to you or put a lawyer tricks and fool you. If the glove doesn't fit it, you must have quit that stuff. I'm an honest guy. This is what I honestly think, and this is why you should think it. So I had to concede something because, quite frankly, the evidence was overwhelming, and the prosecutor hadn't even put in his best evidence.
And at the time of closing argument, is it fair to say that Ms. Vander Ark was not assisting you in your closing argument, given her mental or her physical state in the jail?
We had, before the day that morning, we had stopped talking about what we were doing in court, and it was just a conversation of, will you come to court? That's all we talked about. Will you come to court? And when she couldn't, then we went back to court and we finished up. We had talked about the things I would say, generally speaking, during the course of my representation of her. But the reality is a closing argument is as much art form as in science. I don't know exactly what I'm going to say every time. So I couldn't tell her exactly. She understood the plan. Did she know exactly what I was going to say? No, because I didn't know exactly what I was going to say.
But I want to just clarify, though, your decision to concede manslaughter wasn't an off-the-cuff decision.
Oh, no, it was not. No, it was not.
And you conducted some investigation, and you put a lot of thought into doing that, correct?
Yes.
Okay. So I want to shift gears here into her competency. How many cases have you handled where someone has been referred for competency or criminal responsibility examinations?
3 or 4 a year, so 30 or 40.
Okay. And so have you had situations where you have somebody who absolutely can assist you in any aspect of the court proceeding?
Yes.
Was that the case in this case?
No.
Okay. And during trial, was Ms. Vander Ark alert to her being Ms. Vander Ark?
Yes.
Was she alert to she was in Judge Kacel's courtroom?
Yes.
And that it was the date and time that it was that year?
Yes.
Okay. And she was actively assisting you, it sounds like?
She was.
Okay. And was she assisting by writing notes while you were at counsel table?
Yes, and that was what I do is I can't listen to the witness chair and my client at the same time, so I give them a pad and pen and ask them to write notes and slide them over to me.
And without getting necessarily into what she was writing, was the content of what she was writing coherent?
Yes.
It was attuned to time and place?
Yes.
It was appropriate for what was going on in the courtroom?
Yes.
Okay. So let's talk about Thursday after she testified. Now, you don't recall if you went into the holding cell or the jail with her after the testimony concluded?
Okay, let's make sure I understand. When trial was over, did I go into the jail? Okay.
Thank you for clarifying. That was a poorly worded question. When the proceedings on Thursday, not the last day, but the day she concluded her cross-examination,
yes.
When that day concluded, did you go to the jail to meet with her?
I believe I saw her in the holding cell, which is back here behind the jury room. I think after each day, myself and the social worker involved, we go back and we talk to her for a few minutes, but then we break. That was the plan. Did it always happen every day? I don't remember. I think we did most days. I don't know if we did that day.
So you wouldn't be able to say how she was appearing outside of the courtroom after that?
I have no recollection of her after she walked out of the court that day. Then I don't recall.
Okay. So let's move into that Friday morning.
Yes, ma'am.
That you've already testified about. And you described that she was in a holding cell, correct?
Yes, ma'am.
Do you recall who was in the holding cell with you?
Ms. Vander Ark and my caseworker. Who's my caseworker? My social worker was there. I'm trying to remember which one it was. I don't remember which one it was.
Would it be Melinda Katecki?
Yes,
Okay.
yes, that was Melinda.
Do you remember a couple of jail deputies also being there?
They were in the area, but they weren't in the cell with us. There's a cell area, and they stand outside of that. They weren't in the cell with us.
Okay, so to your recollection, it was you, Ms. Katecki, and your client?
That's my recollection.
Okay. And you indicated that she was on the ground, curled up?
She's on the floor, curled up against the wall.
Okay. And could you tell the court what your conversation is with her, like at the start of that morning, when you first walk in? What's the conversation?
Are you okay? What's going on? Can I get you something? What are you feeling? Can you explain to me what's going on? What was the situation? Ms. Kotecki was also talking to her, the same sorts of questions. What's wrong?
And what did Ms. Vander Ark reply?
Effectively, I can't quote her, is what she said. Her response was that she could no longer, she could not go up into the courtroom today. She couldn't take the trial today. She was having an episode, and she just couldn't tolerate being in the courtroom today.
And at some point you come up to the trial court and you place on the record what occurred, correct?
Yes.
And in that you stated you discussed Ms. Vander Ark's options, correct?
Yes.
Did you in fact discuss her options on how to proceed that morning?
Yes. Yes, ma'am.
Could you explain that conversation to the court?
We explained to her that option one was to come back in the court and just sit there. We're not going to put you on the stand again today, just sit there. Option two was for us to go back and ask the judge to adjourn. That was in fact plan A, to ask for an adjournment to give her, or at least some breathing spell. When this happened a time previously, the judge gave her 5 minutes, but we already had an hour or so in on this thing, so so that was plan B. Plan C was to continue to represent her. If the judge said go, we're going to go.
Did Ms. Vander Ark want the adjournment?
Yes.
Did she want, and if the adjournment wasn't available, I guess, did you discuss waiving her right to be present at court?
I don't think, I don't recall. I don't think I did. I don't think I told her that she had a right to refuse to come to court.
If she signed an affidavit saying that she is voluntarily choosing not to come to court, would that refresh your recollection?
It does. You're correct.
Okay.
Counsel. She did sign an affidavit to that effect.
Okay. And did you know that was happening, or were you aware that was something that was being drafted for her to sign?
Yes, I was.
Okay. And so, does that refresh your recollection about the conversation?
Yes, it does.
Okay.
Yeah.
Now that your recollection's refreshed, do you recall explaining to her ability to waive her presence?
Yes, I remember. In the context of the affidavit, I think we came up and came downstairs a couple times, and when we came down and said, "This is what's going to happen. You have this. If you don't want to be there, you have to let us know." And she signed an affidavit to that effect.
Did you coerce her in any way not to come to court?
No, ma'am.
Okay. Did you want her to come to court?
Yes, ma'am.
Would that have been better for your case if she came to court?
It would have been better. Yes, ma'am.
Did you feel like she understood what was happening to sign that affidavit?
Yes, ma'am.
Or at least to make the choice to not come to court?
Yes, ma'am.
I apologize, I shuffled my notes here. Now, when you were asked about using the word competency, I believe it was on page 3 of that transcript you have there, you said, "Well, that's the word I used." Could you explain your response to that question?
I used it in the layman's vernacular as competency, not as in the legal standard as competency. I didn't mean that she, as lawyers know, that she couldn't participate or that she couldn't understand. I didn't mean it. I meant it as a layman would use the word competent. She just wasn't ready to go. She wasn't able to write me those notes or to whisper in my ear or to participate as I would want her to have. Her life's on the line. It's a murder trial. I want her to be fully able, I was going to say competent again, to participate in the process. This is her chance. And I didn't want her to leave that courtroom thinking that she left cards on the table or whatever the expression might be.
So it was not your impression that she was legally incompetent the morning of that Friday morning?
That is correct.
Now, had Ms. Vander Ark, and I know the court's referenced this before, but Ms. Vander Ark had episodes before, correct?
In my presence, she'd had, if we're not talking about when she saw the photograph, in my presence, she'd had one episode, but she expressed to me during the course of our representation that she'd had others.
Okay. And one of those episodes, and correct me if I'm wrong, but you observed the episode at the preliminary examination where her co-defendant was called to the stand and she had an episode, correct?
I don't remember the timing. She had the episode of the prelim.
Okay. And the record will speak for itself about
Yes,
when?
ma'am.
Okay. Shifting gears a little bit, now it wasn't your strategy to discuss hydration in depth, was it?
Was it my
Dehydration and...
No, ma'am.
Why didn't you focus on dehydration?
It seemed to me that dehydration, along with the corporal punishments, along with the deprivation of food, along with all the other burdens that young man had to go through, were part and parcel of the same issue. Our argument was she did not form the intent to injure this child. So whether she injured him with dehydration, or she injured him by starving him, or she injured him by thermal, it wasn't an issue. The issue is, did she intend? Did she know? Did she create the intention in her mind to hurt this boy? And that was the issue. So I didn't concentrate on the other issues that the coroner said went into causing his death either, because they just weren't the issue I wanted this jury to concentrate on.
Okay. So that was a conscientious choice on your part?
Sure. And we weren't arguing that the boy was dehydrated. We weren't arguing that he had passed away. That he was underfed. We weren't arguing any of that. We were arguing intention.
Do you think if you would have argued that he didn't have his water access restricted, that would have furthered your strategy at all? Or presented the case in a better light for you?
I think I would have lost the jury on that. They had photographs of this boy. And nobody's going to take a look at those pictures and say this boy needed water.
Now, there's been a claim that you provided deficient performance for allowing commentary in lieu of a video. Are you aware of the video that I'm mentioning?
Yes. The best thing I did in that trial was the best thing that happened in that trial was the fact that video didn't come in. That video is literally the worst thing I've ever seen. There is no commentary that can express to a jury how bad that video is. The commentary was by leaps and bounds better for our clients than showing that jury that video. I'm so pleased and grateful that the people did not push to admit it. That video is just awful. And to the day I die, that was the right strategy. It's the best thing we did during trial was keeping that video out. It's just awful. You see it, you'll never forget it.
And just to go back a little bit and expand this, were there in-chambers discussions between yourself, Mr. Roberts from the prosecution, and the court about this specific video and the presentation of it to the jurors?
Yes, ma'am.
Okay, could you just sort of place on the record the summary of that in-chambers
My position was that the video was so prejudicial that nobody who saw it could unsee it and not give it and not absolutely close on. It's just it was, and given the weight of all the other information that Mr. Roberts had presented, it was duplicative, and therefore we shouldn't allow it in. That was my argument. Ultimately, as I recall, Mr. Roberts just agreed not to use it. We use this description, but we wouldn't use the actual video.
But that was due to a strategic stipulation, correct?
Yeah, that was big. That was one of the best things we did.
And it wasn't an oversight that you just let hearsay?
Oh, no, ma'am. That was a relief.
I can just have one moment. Thank you, Mr. Johnson. I have no further questions.
Thank you.
All right, Mr. Ambrose. Any follow-up?
You mentioned that the morning of December 15, 2023, Ms. Vander Ark was on the floor, curled up.
That's the day when she refused to, when she declined to come to court? Is that what you're talking about, counsel?
Yes.
Yes, sir. That's how I found her.
And you did you used the word competent, but you stated that you were using it to the court as part of a, in layman's terms rather than a legal definition.
That's correct.
After the trial in this case, do you recall providing any interviews with the media?
I believe they were standing in the corridor.
Okay.
And I believe they did speak to me.
Do you recall telling, when asked a question about your conversations with, or your interactions with Ms. Vander Ark, that she was in a catatonic state?
I may have used that term, yes.
Okay. And so that's kind of a serious situation, right?
Yes, sir, it is.
And that's more or less what you reported to the court, is that correct?
Catatonic state is a more egregious, is a higher level of incapacity than what I report to the court. And it's what I report to the media.
Yeah, there was some testimony regarding dehydration, and it was your decision. Was it trial strategy that you did not use dehydration as a way to explain the death of Timothy?
Was it? Yes, sir. The trial. Would you like me to elaborate? The answer to your question, yes. Okay. The trial strategy was not to try to explain. There was food in the house. There was water made available. The other children had corporal punishments as well. The decision was not to try to explain that these were causes of death. The decision was to explain that my client never intended this outcome. Does that?
Was there, to your understanding, was there any restriction on water
For
Timothy?
No, not that.
And when's the last time you saw the death certificate?
I would have seen it before trial.
Okay.
That would have been the last time anyway.
May I approach the witness?
You may.
All right. This was, it looks like it was People's Exhibit number 45 introduced at trial. Is that what you recall as being the death certificate?
I don't have any personal recollection, but this is the death certificate of the victim in this matter.
Okay, and what's the first thing that's listed as being the cause of death?
Okay. Cremation. box is that in? Do you know, Ralph?
36,
Okay, I was looking to
near the bottom.
Okay, 36. Dehydration and extreme emaciation.
Okay, and dehydration would be lack of fluids, right?
Yes, as far as I know.
And like you said, there was no restriction on water in the household.
That's what my understanding was. I wasn't in the household, so I don't know if it was or not, but that was my understanding.
All right, I have nothing further on that.
I could just ask a brief follow-up.
Yeah, go ahead.
So, Mr. Johnson, if you had focused on dehydration, would that open avenues to the prosecution to enhance some of their arguments?
I would assume.
Such as the fact that he didn't have access to water when he was locked in a closet, correct?
I didn't want to get into that.
That he did have access to water in the ice baths, arguably.
That's what I was afraid he'd say.
And ultimately, and unfortunately, but by the defendant's actions, Timothy was so malnourished and unable to move that he could not get himself water. Would that be accurate?
I would assume that's the case. At the end, I'm sure that's what the case was.
So there's multiple arguments and pitfalls if you were to take that strategy, correct?
If I would have attempted to argue that whatever in here did not cause the death, I opened the door for Mr. Roberts to show that, okay, it did, and that this wasn't an issue. And I didn't want the jury to hear more of that. I want them to hear that my client just didn't get it. That was the message.
Thank you.
Any follow-up to that, Mr. Ambrose?
No, Your Honor. Thank
you. Mr. Johnson?
Sir.
I have some, well, it's a noon hour. Are you available this afternoon, Mr. Johnson?
Yes, sir.
All right. Let's break. We're going to, since we lost some time this morning, I'm going to have us return at 1 o'clock after lunch. And then we'll resume. Mr. Johnson, you can stand down for now. I would like you back here at 1 o'clock.
Yes, sir.
Anything before we break, Mr. Ambrose?
No, Your Honor. Thank you.
Blomquist.
No, Your Honor.
All right. We are in recess for lunch. Thank you.
All right, looks like they're going to break until 1 o'clock, which is about 50 minutes. So we'll stay here. I'm sorry, I was just sneezing, so I'm a little sniffly. Sorry, guys. So we're streaming Johnny Depp's trial. He's under cross right now, so we're doing that. If you guys want to join us over that stream. We'll put some music on here, and I'll just put up a thumbnail because I don't know what this feed is going to do. Now, let me get some music here for you guys. Let's see. Sorry for being sniffly. Let's see. Yeah, 50, yep. 1 o'clock. They're coming back at 1 o'clock Eastern. So 1 o'clock Eastern. 1 o'clock Eastern. So let me put some music on here. Where's the music? Here we go. All right, so they're going to be at lunch until and I knew that was going to come up. Let me see. Let me find another feed. See if I can find another feed here. That just shows. Maybe hold on a sec. Let's see if this other channel is going to stick with it. All right, no, I guess not. All right, so I'll just stay. All right, we'll just stay here. So they're at lunch until 1 o'clock. Let me put that 1 o'clock. So court is at lunch until 1 o'clock, which is not too long, pretty short. All right. All right, I'm going to go over and watch Johnny Depp while they're at lunch, and we'll see you here in 45 minutes or so.
Lately I've been staring at the dark. Turn my inner demons into art. Struggle with the pain inside my heart. Wish I didn't care about what say what you want to say. What you want to say. What you want to say. What you want. Say what you want to say. 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 What you want to no one. No one. No one.
Hey guys, welcome back. Hope you had a good break. Oh wait, here, hold on. All right, welcome back. Hope everybody had a good break. We're expecting court to start soon. Another few minutes, top of the hour. Hey Mel, how are you? Thank you for joining us, Mel. Let me make sure that I am all caught up. Oh, let's see here. So I wonder who else they're going to call to the witness stand. Oh, you gonna get up for me? All right, thank you. Good girl. All right. Yeah, good kitty. Wonder who else they can call up to the witness stand. Get some kitty love? Sure. There's some kitties. That's so Super Bowl. She was sitting in my chair the whole time. She was actually here the whole time. Lazy boys, yeah. That's a good girl. Yeah, she was actually sitting in my chair the whole time. I think that's ultimately what she wanted, was that she wanted to sit in my chair because she's been kind of, what do you call it? Unsettled. She's been kind of walking all over the place all day. So, yeah. Super Ball's taking a little bath. Hey, bud. What's up, dude? That's a good girl. All right, looks like they are back in court. Just waiting for them to come back. Lazy boys, yes. Lazy boys loves Super Bowl. Thank you, Dragonfly. Oh, here comes another one. Here comes Riker. That's a good girl. Yep, and then we get this showdown over here. All right, hold on. Let me get over. They took down one curtain. They're doing their best to take down the shades now. Yeah, Gordon, I'm sitting in Super Ball's chair, right? Queen Super Ball. That's true. I mean, there's still not justice for Annie Bev, but she's too cute for jail, Lazy Boy says. DA Jules dropped all charges, so Super Ball is free and clear. Super Ball is free and clear. Dragonfly Girl asks, how many do we have? We have 7. We had... you see what's going on back there. We brought Super Ball with us when we moved here, and then Paulie and Rafa adopted us last year. And then Paulie gave birth this past June, and she had 4, and we kept all of them. So now we have 7. Oh. What are you doing? I know that's a disaster waiting to happen, right? They are just going to destroy that. And I only have that down when I stream this way, because if I don't have that down, you'll get blasted by the window. No, Lazy Boys, DA Jules dropped all charges. So if you're pro Super Ball, then you're okay with that. If you're pro Judge Bev, then you would be protesting. I can't, Chris, because it would just blast you guys. It's a window, it's sun. It would just blast you. It would be too bright. It'd just be too bright in here. It's just. It would just be a big blast of white light. So I'm trying to not, just trying not to blast you. Trying to make it somewhat enjoyable to watch the stream. Yes, that is Riker. Yep. Lazy Boys, yes, that is Riker. Right? Yeah, see, it's only when I stream from this angle. Normally I'm streaming over here, and it's fine because there's a wall. But when I'm streaming this way, we have these big windows right there. Beautiful, but Gordon, a bit of interior design going on, right? Mel 7, yep, one for every day of the week. That is true. Yes, they did go to, did I miss the question? Yes. Jenny's answering Jenny Lynn. Yep, it was around 10 after. Yep, that is correct. That is correct. Let me see here. Chris says, I'm not a cat person, but they are really cute. We were dog people. We had 2 Jack Russells, and then I had a cat, and then Superball kind of adopted us after both of our Jacks passed away. So after they passed away, Superball just she's like, okay, I'm here, and then when we moved from that location to this location, we were like, okay, we'll only have 1 cat. Cool. Maybe we'll get a dog, a couple years, who knows? And then last year, Paulie showed up, and then Rafa showed up, and everything was cool. Okay, we've got 2 outside cats, and then they came in, and then we had 3 indoor cats. But Paulie and Rafa were kind of going in and out, in and out. They spend Rafa spends more time indoors. He's probably like 85, 90% indoors, and Paulie's probably more like 70% outside. And then she got pregnant and she gave birth. We thought she'd only have like maybe 1 or 2. We thought, okay, first time pregnant, 1 or 2, we can handle that. Nope. She pumped out 4 little kittens, and we're going to keep them. We've decided we are going to keep them. So so now we have 7 cats. Bisu says, never doubt the cat distribution system. Let's see. JMS dropping some turkeys there. Silver Fox, you had 2 cats, but you're allergic. Oh, so you can't have them anymore. That stinks. Polly is a female. We named her after Polly Gutierrez from The Sopranos. I always forget his last name. Anyway, Polly Walnuts, but Aaron will correct me. I know it's Polly Gutierrez because he has the wings. Remember, so Polly is a female. She's the mother. We don't think it's Rafa, even though one of the 4 is a ginger, but he's got Roger has long fur like a Maine Coon. Rafa has short hair. So, and plus, Fed looks like Roger Federer. He looks like he's got that face of a Maine Coon. So, oh, Burmese cats are hypoallergenic. Crazy Mary Jo says. There you go. Silver Fox, check into Burmese if you really, really, really want one. See, Christine says, my daughter has very pampered kitties. When I FaceTime my daughter, it's funny because I call her cat Sweetie and she runs to the phone when she hears my voice. Oh, that's sweet. Chris, didn't realize it's been 6 months. Fantastic. Happy anniversary. JP, we don't know. Polly got out one night. She was she was doing her thing, and we tried to keep her in. We kept her in, and she got out, and she found somebody. We do not, where we used to live, there were cats all over the place, feral cats all over the place. Super Ball was one of them. And up here, no cats for 2 years, and all of a sudden, Polly and Rafa showed up. Funkmaster, get their DNA tested. That's funny. Trout TV Live saying, woohoo, Chris. Thank you, Chris Wallace. Silver Fox, my first cat was named after our national soccer coach. Nice. Oh, Crazy Mary Jo is also saying Burmese and Siberians are hypoallergenic. Interesting. She is, yes, Funkmaster. We've got Rafa, Polly, and Super Ball are all spayed. Now we got to do the kittens. Now next are the 4. So we have to start doing that like now, like December. We're going to do maybe one a month, one every other month before they turn a year old, because they were born June 5th. June 5th. Yes, we had three dogs and a kitty, as Aaron is reminding us. Yes. Selena K, we have a female ginger and she runs the roost. They're very rare, I understand, right? Female gingers are rare, aren't they? Mostly boys. That's what I understand, Selena. It's only a matter of time. It's only a matter of time. You guys, come on. Stop it. I don't even know why I bother. I don't even know why I bother. It's only a matter of time before that's going to come down. Let's see. Orange tabbies are normally male. Yes, Ronnie, thank you. Gingers are about 80% male. That's what I thought. Yeah. I mean, I didn't know the percentage, but that's what I understood them to be. Oh, Angelique, you have a female ginger too. Interesting. Wow. The only gingers I've known have been male. I've known, what's going on here? All right. Hold on, guys. Hold on.
Resumes. Please be seated.
Mr. Johnson, if you want to come on up. All right, we're back in the record in 23-110 FC People versus Shanda Vander Ark. Where we left off, Mr. Johnson was on the stand. I think the parties had concluded their questions. The court did have some questions for Mr. Johnson. Mr. Johnson, you obviously know you're still under oath.
I do.
All right. Let me just see here. There were some questions about by Mr. Ambrose regarding the suspension.
Yes, sir.
That I think occurred, last year or this year?
I served it last year. It took almost 9 months to get the process rolling, so it actually occurred the year before.
All right. And my understanding, and you've actually been here on a Ginther hearing for that case, correct?
For that case, yes, but not for that issue.
Yeah, not for that issue, but in this court, correct?
Yes, sir.
In this very courtroom, correct?
That is correct.
Okay, and that was for it was People versus LTJ Udall, is that correct?
Yes, sir.
And that was 2019, I think it's 947 FC?
Yes, sir.
All right. And I just wanted, for the record, my understanding is the basis of the disciplinary action was that in that case, let me just go back. My understanding of the facts of that case, very briefly, Mr. Udall was charged with criminal sexual conduct, I think in the first degree. Is that correct?
Yes.
Okay. And the victim of that charge was a client or represented by the public defender's office. Is that correct?
Yes.
And that was in an abuse neglect case or an NA case, correct?
Yes.
All right. In my understanding, you did not actually handle that case, correct?
That is correct.
And was it other members of your office that had handled that?
Yes.
All right. And my understanding is there was a file that was taken from your office detailing this minor child's counseling records, psychological records. Is that correct?
Yes.
And my understanding is that you actually used those in Mr. Udall's defense.
I saw them. They weren't used.
They weren't used, but you certainly used them to prepare.
Yeah, yes, sir. I read them and I knew.
And my understanding is there was supposed to be you were supposed to isolate yourself from that. It was set up to isolate yourself from those files because you knew there could be a potential conflict. Is that correct?
Yes, sir. We had processes in place to make sure that didn't happen.
Okay. And that did not happen.
That's correct. The processes failed.
And so essentially you actually used what were supposed to be withheld from you.
Yes.
In that case, Mr. Udall's case. Is that
yes,
correct?
Sir.
And that was the basis for the judiciary or the complaint,
yes, sir.
Grievance, correct?
Yes, sir, it was.
And you admitted that this happened, and I don't think you contested it at all, correct?
That is correct.
All right. And that's the basis for the disciplinary action, as far as you know?
Yes, sir.
All right. As far as you know, did the disciplinary action have anything to do with, not getting back to your client or not talking to her, doing something that you weren't supposed to do in terms of representation, something similar to what's being alleged in this case?
No, sir.
All right. My understanding is that there was Mr. Udall's case actually had 2 trials. Is that correct?
Yes, sir.
All right. And you represented Mr. Udall in the first trial. Is that correct?
Yes.
And that resulted. What was the result of that trial?
That was a hung jury, Judge.
Okay. And then the second trial, I have, at least according to what the records say, is they occurred in December 13th to December 15th of 2023. Is that your recollection?
Yes, sir.
Okay. Now, you had testified. Mr. Ambrose had asked you about, your stress level at that time. You were on a conveyor belt. Mm-hmm. Was that true at the time of the second trial in Mr. Udall's case? That you were on a conveyor belt? I think that's one of the reasons you said what was going on for the disciplinary action. Is that true?
Judge, it was. Okay. That the workload continued unabated for the time I was at the public defender's office. It was self-inflicted. I didn't go on vacations. I didn't. When I retired, I had 50 more days of vacation time that they didn't even compensate me for. I was at that office and I was doing that work. So yes, it was a continuation of the same process throughout the entire time. The only difference being was when it came to a capital, well, it's not capital in Michigan, but a life case in Michigan, the priority shifted so that the time that I needed for that case would shift to that big case, the life case, as opposed to misdemeanor cases that I might be working on.
And I actually misspoke. So my understanding, I got this trial, Ms. Vander Ark's case actually took place between December 13th and December 15th of 2023. Is that your understanding?
Yes, sir.
I had it wrong. That Udall case happened in April of 2022. Is that your recollection?
I thought so. I thought his was done by the time Ms. Vander Ark began.
Okay, so this trial, did you go right from the Udall case to focusing on Ms. Vander Ark's case? Because it looks like they went from April 2022 and then a little over a year later, you're trying another FC case.
No, I think there were at least a few weeks in between. I don't think so.
All right, now, was there, I mean, looking back on it.
Yes, sir.
Were you able to give Ms. Vander Ark's case what you felt was the appropriate amount of attention for an FC case?
Yes, sir.
Okay. All right. Was that with the assistance of the people you've already indicated?
Yes, the team did.
It wasn't all you, it was the team?
That's correct.
All right. And would you say that you were in charge of the team? Like,
yes, sir.
You weren't absent and said, look, you guys do all the work, I got to take care of everything else? Or were you there for meetings? Were you there for other stuff?
I was there.
Okay. All right. And I'm trying to understand the defense strategy, okay?
Yes, sir.
From what you've testified to, my understanding is that your strategy was to essentially go from a intentional crime to a negligent crime. Is that correct?
In effect, yes. A crime where there wasn't the mens rea to commit harm. So, yes, sir.
At the break, I looked up the jury instructions, and it looks like you, I mean, correct me if I'm wrong, I can't remember exactly, but did you ask for the involuntary manslaughter instruction?
We did not.
You did not?
No, sir.
Okay. But it was included, correct?
Yes, sir.
All right. Was that at the request of the prosecution, do you recall?
Now that you mention it, I don't remember who asked for it. Now that you mention it, I don't know. Because we, obviously, for the record, we discuss these instructions in chambers, and the instruction, it would have come up. I don't know who asked for it. It might have been me. I don't remember.
Okay. So my question is this. You had testified at the beginning of Mr. Ambrose's questioning that Ms. Vander Ark had not given you consent to ask the jury for a manslaughter verdict.
That's correct.
Was that your testimony?
Yes, sir.
But then later on you said the focus was going to be this is not an intentional crime, that there's just something wrong with it, correct?
Yes, sir.
My question to you is, when these discussions between you and Ms. Vander Ark, did she unequivocally say, I am not guilty of any crime? Or was the discussions, look, I didn't do this intentionally, I didn't mean to do this, I'm not going to plead to something that I didn't intentionally do? Was there a dichotomy in that discussion?
The discussions about her responsibility came in two phases. The first phase, when we first met, she told me the same thing she told the police at the time that the boy was discovered, that she found him in the bunk bed, she pulled him down, and she's trying to administer CPR, and et cetera, et cetera. That's the first thing she told me. Then after that, once we got past that and the police reports came in, it was clear that wasn't the situation. We talked about individual defenses to individual crimes. And we covered everything. We covered all the things that she might be, that her conduct might find, the jury might find her guilty of. I never directly challenged her, did you do something here? And that's not my way. If a client either wants to talk to you about that way or they don't want to. But based on the conduct of our conversations, it was clear that she was aware that there's something that's wrong here, and there's something that I may be found guilty of. And that's kind of how we kind of, in order to bridge the gap from her having to confess to me, we kind of discuss it as there's something you might be found guilty of, and this is the things you might be found guilty of, and this is the things that we might be able to achieve if we do these sorts of things. And avoiding, and the bottom line is avoid first-degree murder.
Okay. So it was never, she never said, well, I'm guilty of something. It was more of discussion about, okay, throw it all out the window. What could the jury potentially find? And what's a mitigating thing we can do? Is that right?
That was the strategy, Judge. It was never, I never confronted her to ask her if she did something wrong or not. I gave her the way out. The jury might find you guilty of these things. What are we talking about? And that's how we bridged that gap.
All right. So there was never an affirmation on her part that I recognize that I am guilty of a not unintentional type of charge.
Never before or since.
Okay. And it sounds like initially you wanted to find an expert witness to assist you in that defense, correct?
Very much so.
And you went through, you tried 2 different expert witnesses, is that correct?
We hired 2 different ones. Okay. We talked to 3 or 4 others, and we talked to other people, but we hired 2.
Right. And is it your testimony you could not find an expert that could assist you in that defense?
Yes, sir. That is my testimony.
Did you discuss with Ms. Vander Ark that you were going to make the argument to the jury that she was guilty of an unintentional, negligent type version of either manslaughter or homicide? Did you ever discuss that with her, that was the strategy?
I can tell you how we discussed it. First-degree murder is an intentional homicide. You didn't intend to do anything, and that's the argument we're going to make to the jury. That's how we discussed it.
Did she ever say, wait a minute, no, I don't want you to do that because I'm not guilty of anything here?
No, Miss Vander Ark, again, she was the client from heaven. She sat and she listened and we talked. She understood, and then she trusted my judgment. At least her conduct indicated she trusted my judgment from that second week on. The only thing we ever had a crossword on was about the Michigan-Alabama football games.
So again, she never said, Mr. Johnson, that is not an argument I want to make. I am maintaining my innocence to every single thing, that I am innocent, and I absolutely do not want you to concede any sort of guilt in any way, shape, or form.
That is absolutely correct.
Okay, that she did not.
She did not. Okay. Not ever.
And you feel, coming from defense background, sometimes defense attorneys have a tendency to they think they know more. They know what's better for the client, right?
Yes, ma'am.
I know you don't want to do this, but we're going to do it anyway because I want to make sure that we're successful here.
Yes, sir.
Did you do something that she did not want you to do to be successful, or did you do what you had to do in consultation with her about what the strategy was going to be?
The latter. And again, this is a different client than what we normally receive. This was a client who's much more sophisticated about the law and had much better understanding. And our relationship was more co-counsel, or maybe senior counsel myself and junior counsel myself, but more co-counsel than lawyer layman or layperson. She understood the strategy. She conceded that was the strategy that we were going to use at trial. She understood it. She knew I was going to do that. Did she know the exact wording or how it would come out? No, she didn't, because I didn't. But she understood it, and she understood where we were going with. And at no time did she express concerns that I don't want to do it that way. I want to go on and say I didn't do anything. I wasn't even, whatever her argument would have been. But no, I never asked her if she committed the offense. She never told me she didn't commit the offense.
The other question I have is, in all these discussions, I mean, obviously you're saying not first degree, not premeditated.
Yes, sir.
Not second degree, not, because that's an intentional crime.
Yes.
Right? Not necessarily voluntary manslaughter.
Yes.
But was there ever discussion, well, listen, this is charged, this is, we think, let me back this up.
Okay.
You had said you argued to the jury manslaughter because you were hoping that they would find a middle ground and go for second.
Yeah. Yes.
Was that the strategy that you guys came up with? Or was that kind of like in your mind, you said, well, wait a minute, worst case scenario, maybe it'll be second, but I really want manslaughter?
Okay. No, this is a strategy that I came up with. We did not come up with it. This is the strategy that I suggested to her, and I told her that I was going to follow. And at no point did she express to me that, no, I don't want to do it that way.
When that final day when she was, it was the last day of trial,
yes, sir.
You indicated she was in a ball in the holding cell. Did you ever suggest doing Zoom, potentially? Her zooming in from outside the courtroom for the trial?
No, I did not.
Okay. Did you feel rushed at all that morning by either myself or the court or anybody else to kind of say, let's get this rolling? And
not rushed. I wish we'd have adjourned it for another day to see if she could come around, but no, I didn't feel rushed. I understood that the issues were presented to the court. The court made its call. It wasn't that that the court was trying to rush me to do something. It's just that this is what the court thinks we're going to do, and so that's what we do. I didn't feel rushed. I just felt okay.
It was I think we waited a couple hours, correct?
Yes, sir.
Okay. All right. And now I want to make sure. I mean, you're obviously aware of the legal definition of competency in terms of the state of Michigan.
Yes, sir.
Could she rationally assist in her defense? Does she understand your job, the prosecutor's job, the court's job, the jury's job? Do you feel that she was legally, according to the standard of the state of Michigan,
right.
Would you believe that she was legally competent in everything that you observed that day?
Yes, sir.
Okay. Did she ever ask, say, hey, listen, I want you to ask these certain questions?
No, sir. She directed me to ask very few questions. She had observations, but she didn't.
I'm talking about that day.
Oh, that day.
No, state. Okay.
No, sir.
I think her affidavit says she had a lot of questions that she wanted to ask the witness. I think part of, I might paraphrase it. Mm-hmm. I'm just wondering if those were ever communicated to you when she was in that state.
No, sir.
Okay. All right. That's all I have. All right. Any follow-up, Mr. Ambers?
Yes.
Yeah, go ahead.
It was your request, the lesser included. Is that correct?
Probably. Okay. It was a chambers discussion when we talked about the instructions, and so I don't have any specific recollection, but probably I can't think by the people would want that instruction.
Okay. May I approach?
You may.
And this is a transcript of December 15th, 2023. Page 41 near the bottom, and going to the next page.
Okay.
Does that refresh your recollection that it was your desire, your request for the involuntary manslaughter instruction?
Be honest, counsel, I still don't remember asking for it, but I don't have any reason to dispute what's written there in the transcript.
And it does say that Mr. Chambers or Mr. Johnson is your. So my understanding from our discussion in Chambers, Mr. Johnson, is you're requesting an instruction on lesser included offense of involuntary manslaughter. Is that correct? And your response was, that is correct, Judge.
Okay.
All right?
Yes, sir.
I agree with that. So it was your request.
Clearly.
And so my client's, Ms. Vander Ark is not in the courtroom at this time, correct? December, that's that Friday.
It's that same day?
Yes.
No, she's not in the courtroom.
And you're not discussing involuntary manslaughter with her when she's balled up on the floor, right?
That's correct.
And she's catatonic, right? What you said.
It's what I said to the press, sir. She was distraught, and she was literally curled up in a ball and crying on the floor.
And you're not discussing with her at that time, or are you? Hey, I think I can go with the involuntary manslaughter. What do you think?
Correct.
All right. And throughout, from day one, Ms. Vander Ark said that she was not guilty of this offense. She maintained her innocence. Is that correct?
As I've said, I never asked her if she did it, and I don't recall her saying, I didn't do this. There's quite literally videotape of her conduct. So I don't recall her ever saying, I didn't do anything. What I recall is she never told me that she intentionally did anything to her child or to any of her children. And that's what I recall. I don't recall her saying, I'm not guilty, this is not me, I didn't starve my child, that sort of thing.
Did you guys ever have a discussion? Ms. Vander Ark, you kind of meet these elements of involuntary manslaughter. You want me to see what I can do with the prosecutor, see if they'll accept a plea?
Sort of. What we talked about was she's charged with this homicide, and these are the possible outcomes a jury could legally come to, and these are what they require, and it may be and we talked about it. If we're winning the trial, what do we do? If the trial's not going sideways, what do we do? That sort of thing. But she understood that there are options, and that and during our conversations, my conversations with her, that we talked about what we might argue on if the facts support it. Does that make sense?
Well, you mentioned on direct in the morning, it was kind of your decision to argue to the jury that she's guilty of involuntary manslaughter.
That's correct.
My client, Ms. Vander Ark, never said, I'm guilty of voluntary manslaughter.
That's correct.
And just as a general question, on December 15th, when she was, on the floor and in distress, did you request any type of medical assistance or to have her evaluated?
No, sir.
Your Honor, I don't have any further questions.
Just a couple briefly, and Your Honor, I guess I would just ask the court at this point in time to take judicial notice of the opinion and order regarding new trial in the LTJ Udell case. I do have extra copies. I wasn't anticipating admitting it, but given the court's questions, I think it's just come up that there's been a Ginther hearing. This is the court's ultimate opinion on the matter. So I just ask the court to take judicial notice. And I do have a copy for admission if the court wants it that way versus...
Yeah, that's fine. I think I can take judicial notice of it, right, if you're asking, because it's in the file, so.
I would just mark it as people's two, or proposed to.
All right, Mr. Ambrose? Any objection?
No. Okay. Court record.
Thank you. Do we have Exhibit 1, too, by the way? Is it still on this?
It is.
Is it needed anymore, or I was just going to make sure I keep track of the exhibits, so. All right, good enough.
Okay. Mr. Johnson, is it? I'm sorry, Your Honor, may I proceed?
Oh, so this is the opinion order in the LTJ Udell case, correct?
Correct.
Okay, all right, I wasn't, Mr. Ambrose, were you aware of that?
Yeah, I mean...
I wanted to make sure we're on the same page.
Yeah.
Okay, yep, I remember it, so wrote it. Good enough. Go ahead.
And just to confirm, it's been admitted.
It is, yes.
Mr. Johnson, is it fair to say that you're aware that involuntary manslaughter is a necessary lesser included offense to murder?
Yes, ma'am.
Okay. So if the record shows that you requested it, would that be a standard course in an open murder charge to ask for that?
Most certainly.
And you did in fact go over involuntary manslaughter and what that would entail with your client?
On multiple occasions.
Okay. And so it's not that she's in the jail, she's away from you, and you just decide to ask for the instruction right then and there without consulting her?
Well, I didn't ask her if we could put in the instructions, but we talked about that argument being an option.
Did she condone that option?
She doesn't do that. She doesn't say, okay, you got it, I will do it that way. She simply, I tell her this is what I think we should do, and she nods and yes, and okay, and that sort of thing. She's not the kind of person who was going to challenge, I think. She understands and she trusts.
Did you feel that she was aware about the strategy about attacking the mens rea elements?
Yes, ma'am.
And based on your knowledge, mens rea is different for first degree, second degree, and manslaughter, correct?
Based on my knowledge, yes.
So while you might not have used the words manslaughter, was she aware that there was going to be some concession of mens rea in some way?
Okay.
Maybe negligence or something along those lines?
We discussed options prior to trial, and I told her what the options were, and that depending how the evidence came in, we would select one of the options. One of the options I told her that I would be selecting would be this negligent homicide argument. So did we sit at the table and talk about it during the trial? We did not. But she was aware that was an option, and she was aware I was considering it, and she never objected to it.
Thank you.
Mr. Ambrose.
Did Miss Vander Ark ever express to you her guilt of anything?
No.
And her testimony at trial, would you agree, was an expression of her being not guilty?
Yes.
Of her belief?
Yes.
That she was not guilty of any type of crime?
Yes.
I don't have any further questions.
Top to that?
No, thank you.
All right. Mr. Johnson, I just want to clear, I think we're all dancing around the same question here. Did you ever say, hey, listen, I'm going to her, in those words, we're going to go for involuntary manslaughter?
No.
When you said possible outcomes, did you mean, hey, listen, open murder, you can be first, second, voluntary, involuntary? Is that what you discussed with her?
That's what we discussed.
Okay. And did you discuss all the elements of all those?
Yes, we did.
Okay. And it sounds like you discussed 1 and 2 are off the board, correct? I mean, that was not something you guys were going to argue, correct? First and second degree.
Most certainly not.
Okay. And when you guys talked about, so my understanding is as the trial progressed, you were waiting to see how the proofs came in, to see exactly what manslaughter was going to be argued or just complete in it. I mean, did you ever foreclose the idea of the argument to the jury that completely not guilty of everything?
No, sir. That's the first argument.
Okay. And then was it, okay, listen, depending on how things go, then we might have to say, all right, well, that's out the window. Maybe we should argue involuntary manslaughter.
Yes.
All right. When you guys discussed this, did you use those terms, involuntary manslaughter?
Yes, by name.
Okay, so you actually said involuntary manslaughter to her.
Yes.
And you believe she understood that?
Yes, both manslaughter by name. She's a lawyer. She understood. So I wasn't as reticent about not by breaking it down as I normally would be. She understood all four of the options, and we talked to them by name.
Okay. When did it become apparent to you in the course of the trial that the complete innocent verdict was gone? The fact that you were going to go for not guilty completely. That you said strategy number one. When did that occur to you that that went out the window?
Judge, if you'll recall, there was a point in the trial where the witness testified that he sent my client a photograph on his phone of Timothy, and he was shirtless, and the pants were falling off of him, and he sent this photograph to my client, and my client saw it and responded to it. At that point, given that the jury, at that point, it became clear to me to tell this jury that there is no guilt here, was not going to be an effective argument for this client.
Was that discussed with Ms. Vander Ark?
Specifically, no. Not that specific.
After that day, did you say, hey, listen, option one's off the board, we're going to have to go with option two?
No, sir.
At any point in time was it discussed?
No. No, I did not. I would assume that had she been here, we may have, but that's just an assumption. I don't know. But certainly the realization, the decisions that were being made during trial, whether or not she was going to testify or not, that was done at the point when it became obvious that it might help her. But matter of fact, that's the other decision that was made when that picture came in, that she's going to have to testify. But no, there wasn't a sit-down discussion saying, "Hey, we're gonna go for an involuntary manslaughter here." That did not happen.
Were there previous discussions that at some point that could happen, that you'd have to be, one was off the board, you have to move on to option two?
Were there? You mean
with Ms. Vander Ark?
Yes, that was discussed. Yes, that was discussed along with, and I reviewed the file, I knew it was in it, along with the likelihood that not guilty was not likely here, that we would probably be doing something to make sure you don't spend the rest of your life in prison.
When the option of involuntary manslaughter came up in all these discussions, was it ever expressed by Ms. Vander Ark, absolutely not, I'm innocent?
No.
All right. Sorry to open the door again. Mr. Ambrose, any other questions?
Yes, I mean, okay, so during the whole trial, you hear all the prosecution's case, right?
Yes, sir.
And in the trial, you make a decision, or you discuss with Ms. Vander Ark that it's probably in her best interest to testify, right?
Yes, sir.
And that occurs when this photograph shows up or appears. That was a reason to have her testify, or is that?
Yeah, there was as you know, with trials, the information accumulates, and when that piece came in, that.
Now, during your questioning of Ms. Vander Ark, do you ever ask her, Ms. Vander Ark, or it sounds to me like you committed some sort of crime?
Did I say that? No.
Yeah. And you never asked her on direct examination, well, don't you think they have a case here for involuntary manslaughter? Do you ever ask her anything like that during the trial?
No.
And I think on direct examination, you kind of said that it was your argument to make to the jury that she was guilty of involuntary manslaughter.
Yes.
And yeah, I have nothing further.
Ms. Bloomquist.
Just very briefly. She wasn't convicted of manslaughter, was she?
No.
So the jury rejected your concession anyway?
Yes.
So there's no, I'll just, never mind. I have no further questions.
Any follow-up to that, Mr. Ambrose?
I'm through.
All right, good enough. May this witness stand down, Mr. Ambrose. May he be excused.
Yes, thank you, Mr. Johnson.
Ms. Bloomquist? All right, thank you, Mr. Johnson.
Thank you, Your
Are
Honor.
excused. All right, Mr. Ambrose, you can call your next witness.
I will call Shanda Vander Ark.
All right, Ms. Vander Ark, if you want to come on around. Please remain standing and raise your right hand to be sworn as best you can. This matter now pending. Do you swear or affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, put your hand down and grab a seat. Please state your name for the record, spelling your first name and last name.
Shanda Vander Ark, Shanda Vander, space capital ARK.
All right, go ahead, Mr. Ambrose.
Ms. Vander Ark, you heard the, well, first off, your medical condition. Let's just briefly go through that. How's your condition right now?
I'm miserable. I'm lightheaded. My head is just splitting. The back of my neck hurts constantly. It's something that goes along with the thyroid issue, I guess. I've been shaking. This is almost constant now. It started a couple days a week for a few hours at a time, and it's almost constant now.
Would it be your preference to testify at another time?
Absolutely. I feel like garbage.
With that, Your Honor, I would renew my request for an adjournment.
Can I have a sidebar with the attorneys real quick? All right, we're back on the record, and People versus Vander Ark. Ms. Vander Ark, you can stand down. You can go sit next to your attorney. Well, this is, as a practical matter, it's 1:49 p.m. The people indicate they have 3 witnesses they wish to call. Mr. Ambrose obviously prefers his client be in a better medical condition. Quite frankly, this is likely to go on past today anyway, so because of that,
No.
there's really no point right now in pushing her testimony forward right now if she's not feeling well. I think the parties, and correct me if I'm wrong, agreeing. Mr. Ambrose, you don't have any objection to the prosecution at this point in time calling her witnesses out of order. That way we can come back here for Ms. Vander Ark. Is that true?
That is true.
Anything, Ms. Bloomquist?
I'll leave it in the court's discretion, but I'm ready to proceed with my witnesses.
Okay, well, let's do that. So, Ms. Bloomquist, you can call your first witness.
The people call Melinda Kacel.
Ms. Kotecki, if you want to come right up here, please. Just come right around. Raise your right hand and be sworn, please. This matter now pending. Do you swear or affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, put your hand down and grab a seat. Please state your name for the record, spelling your first name and last name.
Melinda Kotecki, Melinda Kotecki.
Go ahead, Ms. Bloomquist.
Hey, good afternoon, Ms. Kotecki. Could you please state for the record where you're currently employed?
The Muskegon County Public Defender's Office.
And what is your job title there?
I'm the Chief Social Worker.
And how long have you been employed there?
Just over 2 years.
And before you were at the Muskegon County Public Defender's Office, what's your educational history like?
I obtained my bachelor's degree in social work from Kuiper College in 2011 and then got my master's degree in social work from Western Michigan University in 2015.
And did you work anywhere after you received your degrees before the Muskegon County Public Defender's Office?
Yes. After I got my bachelor's degree, I worked at an inpatient psychiatric hospital, Pine Rest, and also worked at a residential treatment center for eating disorders. After I obtained my master's degree, I worked at Community Mental Health of Kent County for 8 years before coming to the Public Defender's Office.
Okay, so how many years in total have you been a master's level social worker?
It'll be 10 in May. Yes.
And were you the social worker assigned for the Public Defender's Office to the case involving Shanda Vander Ark?
For part of it, my understanding is I believe that she was arrested prior to my hire. Once I was hired in September of 2012, 23, that's when I began working on the case.
And could you just describe for the judge, was there a defense team working on Ms. Vander Ark's case?
Yes. In addition to the attorney, Fred Johnson, there was also a second chair attorney, myself. My understanding is that the social worker prior to my hire had met with Ms. Vander Ark, and our office also utilizes a research attorney and an investigator.
So this wasn't just Mr. Johnson and yourself, there was a whole team?
Correct.
Correct?
Yes.
Okay. And did you meet with Mr. Johnson and Ms. Vander Ark together?
Yes.
On this case?
Yes.
How many times would you approximate that happened?
Prior to her trial, I believe twice. During her trial, we met daily.
Did you sit in on the trial?
Yes.
And I apologize, I'm not aware, but where were you at during the trial? Were you near counsel table or were you in the gallery?
Yes, I was near counsel table, not at the table with Fred and Ms. Vander Ark, but in the chairs directly behind.
So you were aware of what was going on during the trial?
Yes.
Were you there every day?
Yes.
So let's talk about the time before trial and those meetings between Mr. Johnson and Ms. Vander Ark. How would you describe Mr. Johnson's interactions with her?
I would, from my perspective, it seemed as though they had a good working relationship. They seemed as though they, communicated freely, both about the case and even just seemed to have an overall good rapport, I would say. They both were big sports fans and they talk about football. From my perspective, recognizing that they likely had meetings without me present as well, it seemed as though they communicated openly with each other.
Did it ever appear as if Mr. Johnson was just going to do things his own way without consulting her or taking her feedback?
Not at all.
Was he receptive to collaboration with her?
Yes.
How was her demeanor in those conversations?
I would say that she seemed very engaged. She was very eager to offer her own thoughts and feedback about kind of case strategy and its, I guess, demeanor, mood-wise. She seemed, I guess I'm repeating myself, but the best word I can think of is she seemed very engaged.
Now, you did mention, though, that she had thoughts on strategy. Were you present for discussions on trial strategy?
Very minimally.
Okay. What was your minimal involvement on that? Or at least what did you observe, if anything?
I want to make sure, I guess, that I recollect as clearly as possible, so excuse my pause. The conversations that I remember involved talking about obtaining an expert evaluation, a psychologist to evaluate Ms. Vander Ark, and we all agreed that that was a good next step. So that's the primary discussion that I recall as it pertains to strategy.
Okay, so obtaining experts and seeing what their opinions would be.
Yes.
How generally was Mr. Johnson's tone with her?
He's one of the friendliest, warmest individuals you probably will ever meet.
And he continued that in his client meetings with her?
Yes.
Did Ms. Vander Ark ever complain to you about Mr. Johnson?
No.
Did you also assist in this case with Mr. Johnson when the defendant was not present?
Yes.
Okay, how so?
He and I would primarily discuss any updates if we were waiting for the psychologist to report back to us about his findings, or I guess that's the primary thing. I can't recall anything else specific.
Did you assist in sort of facilitating the interviews with the expert witnesses?
Yes.
Okay. And specifically, did you assist in or did you participate in the interview with Dr. King?
Yes.
And when I say that, I don't mean your interview with Dr. King, I mean the
Correct.
defendant's, correct?
Correct.
Okay. And ultimately, at the end of that interview, was a preliminary assessment given by Dr. King?
Yes. I was in, I guess to clarify, I am not the person who initially contacted Dr. King to arrange the assessment. I believe that was done by the social worker that was employed before me. When I was hired, that is when I kind of took over that role. I did participate in the interview with Dr. King, and after Ms. Vander Ark had ended her portion of the call, Dr. King and I were still on the call together, as well as I think he had a research assistant that was present. And I am not quoting by any means his exact words, but his initial or preliminary assessment was that he did not feel that Ms. Vander Ark was incompetent or severely mentally ill, and felt that he could not provide a good defense for our office.
Was Mr. Johnson on the call at the same time as you, or was that just you?
He was not.
Okay. So you obtained that information. What do you do with it?
I told Mr. Johnson about it.
And then, to your knowledge, and only answer if you know, did Mr. Johnson speak to Dr. King as well?
I don't know for sure. I know that Dr. King sent us a report. I don't know if they had a separate conversation.
But he wasn't a party to the conversation with you and Dr. King?
Correct.
Okay. So, Ms. Katecki, in your professional capacity, do you sort of have to assess whether or not individuals are alert to person, place, and time?
Yes.
Okay. And do you just sort of naturally start to do that when you're communicating with defendants at certain points?
Yes, definitely. I mean, most times that I meet with a client, I, have my own kind of internal process as far as the things that I'm looking for, assessing, as you said, to kind of a mini mental status exam of sorts. So a person being oriented, as you said, is a component of that, whether or not they're having thoughts of harming themselves, other people, whether or not their thoughts are logical, coherent, things like that.
So did you just sort of relay the whole checklist, or is that just a brief snapshot?
That's just a brief snapshot.
Okay. So could you just walk us through what your general checklist would be when you're communicating with a defendant?
Sure. I would note any kind of observable things. So, like, are they disheveled? Are they, as best they can, given the circumstances of being in jail, kind of tending to their hygiene? Is their speech pressured? Is it unusually slow? Sometimes that can be an indicator of like a thought disorder, if they're experiencing what we call thought blocking. Sometimes if people are doing what a kind of a clinical term, being like loose associations, so making connections with things that you or I would not make connections with, or hearing messages from, that you or I are not hearing, so kind of responding to internal stimuli. And what I mean by that is, do they appear to be hearing voices? Those are, the primary things that I'm looking for.
So turning to the trial in this case, was Ms. Vander, I know I'm pointing over here where my table is, but Ms. Vander was seated over here, correct?
Yes.
And so were you?
Yes.
And you were able to personally observe Ms. Vander Ark throughout the trial, correct?
Yes.
So let's start with the first couple of days.
Okay.
Did she have any concerning behaviors on your sort of internal checklist, for lack of a better term, during the first couple days of trial?
No, I would say similar to prior meetings with Ms. Vander Ark and Mr. Johnson, she seemed very engaged. She was frequently taking notes. She would lean over, and communicate with Fred. I'm not privy to what they were discussing because those were often in whispers, but she seemed alert and oriented in all aspects.
Did you converse with her at all during the first few days of the trial?
Yes.
Was there anything remarkable about her conversation that alerted you to a mental impairment?
No.
Now, I do want to jump into the time frame after she testified.
Okay.
Were you present for her testimony?
Yes.
Okay. Did you view, and that was a Thursday, do you recall that it was a Thursday?
Yes.
Okay. Do you know, after court concluded for the day, did you speak to Ms. Vander Ark after the proceedings ended?
I don't remember if it was, I know I did on Friday. I don't know if I did on Thursday after court proceedings finished.
So let's jump to Friday.
Okay.
Did you respond to the jail?
Yes.
And you observed Ms. Vander Ark in the holding cell?
Yes.
Could you tell the court what you saw?
Yes, I was on my way to court when Mr. Johnson contacted me and said that he needed my assistance down in the jail because Ms. Vander Ark was having a difficult time. So when I arrived, he was already in the holding cell with her, and she was very distressed. She did not want to go upstairs and repeatedly said that she couldn't do it. And Mr. Johnson and I repeatedly, we tried, I guess every way we could think of to try to provide the support that she would need to go upstairs. So I don't know how much detail you want me to.
So let's unravel this a little bit. So Mr. Johnson was actively attempting to get her to come to court.
Yes.
And you were assisting him on that?
Yes.
And it was your testimony that she did not want to come up to court. Is that correct?
Correct.
Did she say it in those words, that she didn't want to come?
I don't know. I'm sorry.
Was she experiencing any psychosis?
She did not appear to be experiencing psychosis. I would say that she appeared to be very anxious.
How was her speech?
It was, I would say, pressured, but kind of like going back to those pieces that I touched on earlier, although pressured, it was still logical. It was relevant to the topic at hand. She wasn't making those loose associations. So I would say again that pressured speech would be consistent with anxiety.
Was she oriented?
Yes.
Okay, meaning she knew who she was and where she was at.
Absolutely.
And from her conversations or her statements, she knew what was upstairs, which was a trial, correct? Okay. Did she appear to understand sort of what would occur at the trial?
Yes. Yes.
So she understood that there'd be additional witnesses.
Correct.
And sort of the court process.
Yes.
Okay. So she wasn't delusional?
No.
She wasn't catatonic?
No.
And what, when I say catatonic, what do you take catatonic to mean?
The most kind of classic catatonia presentation is one that is withdrawn. So in that particular presentation, oftentimes people are not responsive to communication. They might not even be responsive to touch or painful stimuli. They often are not eating, they're not drinking, they are kind of in a stupor.
Did you see any of those signs with Ms. Vander Ark on that day?
No.
Were you present for any discussions about Ms. Vander Ark waiving her right to appear at court?
Yes.
Could you tell the court what those discussions were?
When we were in the holding cell and there was a great deal of back and forth, I would say. At times, Mr. Johnson would leave to, I believe, go upstairs and communicate with those who were up here, whether in chambers, about the status of Ms. Vander Ark, that she was having a difficult time. He would return, and eventually, it was my understanding that, since it became apparent she was not going to come upstairs to court, that she could waive that participation. And so that was explained to her. I could not tell you, I guess, the exact language that Fred used.
To her?
Mr. Johnson. Yes.
But there was discussion of that.
Yes.
And were you aware that she filled out an affidavit or a signed document of some sort regarding her waiving her presence in court?
I guess I don't remember that exactly, no.
But you do specifically remember Mr. Johnson explaining
Yes.
that to her?
Yes.
What was her response?
That is what she wanted to do.
Did she vacillate at all on that, or was she clear?
She was clear.
Did she give any further commentary on it?
If anything, I would say that she seemed appreciative because she very much did not want to go upstairs. So she felt, or it appeared as though she felt relieved by that option.
So if there's a claim now that she never waived her right to not come up to court, is that accurate?
No. As I said, I cannot recall seeing her sign an affidavit. I do remember it being explained to her, though, that this is what she would be opting to do, and that she verbally said that, yes, that's what she would like to do.
Did you see anybody pressure her into that choice?
No, it was quite the opposite. I feel like we were putting as much pressure as we possibly could to encourage her to come upstairs.
Thank you. I have nothing further.
All right, Mr. Ambrose.
Did you say that you were on the call with Dr. King?
Yes.
And you're part of the Muskegon County Defender's Office?
Correct.
Your involvement with Ms. Vander Ark and Mr. Johnson, more or less working together as a team, is that an accurate
Yes.
assessment? Okay. Did you view Dr. King's evaluation?
I'm sorry?
Did you review Dr. King's written evaluation?
Yes.
And in his evaluation, do you recall him stating that Ms. Vander Ark continues to insist she did nothing wrong and was not convinced that her actions and instructions caused the death of her son?
Yes.
On December 15th, what was your observation of Ms. Vander Ark? I mean, where was she when you first observed her?
Was December 15th Friday?
That final day of trial.
Thank you. When I first arrived, she was in the holding cell with Mr. Johnson.
What was her physically where was she? Was in the holding cell, but how was she? Was she in a chair? Was she laying down? What was her condition?
I believe that she was sitting in a chair, and if I may, I believe she was sitting kind of with her knees drawn into her chest.
Okay. Did you appear after Mr. Johnson?
Correct.
Okay, and so he was already in there with her in the room?
Yes.
Did you ever request that she be seen by any medical personnel?
No.
You mentioned her speech was pressured. Can you elaborate a little bit on that?
Sure. When I say pressured speech, I primarily mean that it was kind of a rapid pace. I would say that's what I mean, is that she was speaking very quickly.
I have nothing further, thank you.
Yes, Wes.
Why is it that you didn't request medical on December 15th of 2023?
From my perspective, it didn't appear to be a medical crisis in nature. She wasn't expressing medical concerns, wasn't expressing, pain, anything of that nature. It seemed to be more, as I mentioned earlier, kind of anxiety related.
Do you think that did it appear to you that it was sort of related to the situation of the
Definitely.
trial?
Yes.
Okay. So there wasn't an actual medical issue that you were concerned about?
No.
Thank you. I have nothing further.
Mr. Ambrose, any follow-up?
You're not a medical doctor.
I'm not.
And, yeah, I have nothing further. Thank you.
All right. May this witness be excused? Ms. Bloomquist?
Yes, Your Honor.
Mr. Ambrose, may the witness be excused?
Yes.
All right. Thank you, Ms. Kotecki. You can sit down. Does anybody need to take a break right now?
I'm at the court.
Why don't we take a 15-minute break just in case Ms. Vander Ark needs a break, and then we'll be back here at 2:30.
Thank you.
We're in recess.
All right, they're going to go to recess. So they're just going to take a break. Break to 2:30. All right. So a 15-minute break. All right, you guys. Let me just post this again, and I'm going to pull it up. All right. We know people have strong feelings about Chandra, but no name calling, monsters, evil, all that stuff. We're not. We have to calm that down a little bit. All right, because it's just. I know you guys don't like her. I don't like her. I'm not making excuses for her. Just take a pause on that, okay? Because we're gonna start to remove those comments. We don't want to have to time you guys out, because just take a pause on the name calling. I don't like her. I know you guys don't like her. She did a horrible, horrible thing. But let's just take a pause. Take a pause on the name calling. I know, JRN, you calls it like you sees it. So let's just take a pause on that. Yeah, we're not giving her any respect. Don't worry, that is not respect at all. We're just saying, let's just take it easy. That's all. That's all I'm asking. Rainbow Rabbit Hole. Focus comments on behavior, not people. Can we say she's not a good person? I don't know. You guys have me in a quandary because I don't like her any more than anybody else does, but you don't see me up here yelling, screaming with pitchforks and, so I don't know. I guess I'm just asking for you guys just to take a pause. That's all. We don't want YouTube to get mad at the channel. So 15-minute break, now down to a 20-minute break. I'm sorry, 10-minute break, 2:30. Yeah, come on, you guys. Don't fight with me. Don't push back on me. Just please. Just don't. Please. Okay? I'm just asking you to respect our channel. That's all. I'm asking you to not to do something. I'm asking you just to take a pause. Don't push back on me. Thank you. Please respect our channel. I know you guys can. I know I've seen it. We've watched a lot of trials together. I know you guys have it in you.
back in the record in People versus Vander Ark, 23110 FC. Ms. Bloomquist, you can call your next witness.
Thank you. And I guess just one matter for the record before I call my next witness. I know I previously said that I had 3 witnesses. There's been another witness that just based off of some discussions outside of the courtroom. I may add a 4th, but I didn't want to catch Mr. Ambrose completely off guard because we discussed witnesses last week. It would be potentially Mr. Roberts, just for a couple of communications that he was there present for with Mr. Johnson. So I just wanted to alert the court to that since I previously said 3 witnesses.
Okay, Mr. Ambrose?
I'd object, Your Honor. I mean, I'm prepared for 3 and we have to.
Well, let's see what we can get done, and then we'll go from there. So if Mr. Roberts is a potential witness, then I'll have him excuse himself. So I'm going to reserve a decision at this time on that, see where we're at. I'd like to get as much done as possible.
Your Honor, I anticipate I could be done as early as 3 o'clock today.
Okay, all right.
So I call Katie Evans.
Okay.
Can you get into some things that I can state a week for about Johnson? I can further go into it. And I can nail down some questions.
All right, Ms. Evans, just come right on up and raise your right hand to be sworn. This matter now pending. Do you swear or affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, put your hand down and grab a seat. Please state your name for the record, spelling your first name and last name.
Catherine, Katherne, Evans, Evans.
Go ahead, Ms. Bloomquist.
Where are you currently employed?
The Sheriff's Department, Muskegon County Sheriff's Department.
And what's your current assignment?
Court Sheriff's Deputy.
So you work here in the courthouse, correct?
Yes.
And back a couple years ago, were you assigned to work the trial of the people of the state of Michigan versus Shanda Vander Ark?
Yes.
Okay, and what was your role in that trial?
It was my job to transport her from the jail to the court and then up to the courtroom and then back down.
So specifically drawing your attention to the final day of the trial, do you recall a situation that occurred in the holding cell of the jail?
In the court services area?
Well, I guess, thank you for correcting a poorly worded question. Did you have interactions with Ms. Vander Ark on the morning of December 15th, 2023?
Yes.
Where did those happen?
In the court services area.
Okay. And is that a holding cell of sorts?
There are holding cells, but where we mostly interacted would have been kind of off to the side.
So you did, in fact, interact with Ms. Vander Ark?
Yes.
Okay. And did you see her have interactions with her attorney, Mr. Johnson?
Yes.
Were you a part of any of those?
I was not.
Okay. Is it pretty standard procedure that once the attorney's there, you're not involved, correct?
Correct.
At some point, though, did you have communication with Ms. Vander Ark?
Yes.
Okay. And what did she say?
I was putting a taser on her ankle for coming up for court.
Is that standard procedure?
Yes, everyone that's in a jury trial.
Okay, so you're putting the taser on, and then what happens?
And she made a comment to me saying that if she comes up here, she was gonna attempt to run.
Did she appear alert and aware of what was going on around her?
Yes.
Did she know what the taser was being put on for?
Yes.
To go to
we've
court,
done it multiple times throughout that trial.
Okay, and had you been the one personally to put that on her the other days?
I don't recall, but me or Levine.
Okay, but one of you?
Yes.
Would put that on her before court every day of her trial?
Yes.
And this was the last day, correct?
Yes.
And did she appear catatonic?
No.
Did she appear to be conversational?
Yeah. Talked.
Okay. Anything about your conversation with her that made you think that she was having a mental health episode?
No.
Okay. Thank you. I have nothing further for you, Deputy.
All right, Mr. Ambrose.
Was your former name Bassett?
Yes.
Okay. And What was your first encounter with Ms. Vander Ark on December 15th, 2023?
Probably when she came down to get dressed for the jury trial.
Okay. And you mentioned that she stated something along the lines of that she would run?
Yes.
Okay. Do you recall preparing any type of report about Ms. Vander Ark from December 15th, 2023?
In reference to that situation?
Or any situation?
Not that I recall.
Your Honor, may I approach the witness?
May.
Can you identify that?
Yes.
What is that?
It's a report that was done by the jail.
And your name's on it, correct?
Correct.
Deputy Bassett.
Yes.
And in this report, there was a remark about her being, Ms. Vander Ark being suicidal.
Correct.
And is there anything in there about her stating that she was going to run?
No, because this more than likely would have happened after the whole situation.
Okay. And
I did not type that report.
okay. Fine. But you were there.
I assisted the jail in a situation because you need 2 females.
Okay. And she was placed in a suicidal unit.
Yes.
That seems to me a pretty drastic situation.
Correct.
Nothing further.
Mr. Quist.
I have no follow-up.
Deputy Evans, how many times were you working through most of the trial for Ms. Vander Ark?
If I recall, I was here every day.
Okay. Did you have a chance to observe Mr. Johnson with Ms. Vander Ark? I mean, whether it be in passing or even up in the court area, anything like that?
There was a few times where I had transported Vander Ark and Mr. Johnson down the elevator to the jail, and then that way they could talk in private.
Okay. And when you went down to the jail, were you ever standing outside the room? Did you kind of hold there and just wait until they needed to come back up?
No, normally I would go back to like our office, which is like a bubble, and they were kind of on the other side of the glass.
Okay. Did you ever observe them body language of not getting along, being upset with each other, being angry at each other, any arguing, yelling, anything like that?
No, never heard any yelling. I didn't know if it was a while ago, so sorry, but I don't recall any body language or anyone being upset.
So, as far as you didn't observe any behavior would indicate that Ms. Vander Ark and Mr. Johnson were having some sort of disagreement or argument?
I didn't see anything.
Any follow-up to that, Mr. Ambrose?
No.
Mr. Bloomquist?
None, Your Honor.
All right, may this witness be excused,
Yes.
Mr. Bloomquist? Mr. Ambrose?
Yes.
All right, you can stay down, Deputy. Thank you.
Thank you.
All right, you can call your next witness.
The people call Deputy Tim Levine.
All right.
Yeah, it's more important information. I was just using.
Deputy Levine, if you want to come right on up front here. And please raise your right hand to be sworn. It's a matter not pending. Do you swear or affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, put your hand down and grab a seat. Please state your name for the record, spelling your first name and last name.
Tim Levine, T-I-M-L-A-V-I-G-N-E.
Go ahead, Ms. Bloomquist.
All right, good afternoon, Deputy. How are you?
Good afternoon. Good.
So where are you currently employed?
Muskegon County Sheriff's Department.
How long have you been employed there?
Oh, probably 14 here.
Okay, and what's your current assignment?
I am with the Court Services Division.
And back in 2023, were you also assigned to court services?
I was.
Okay, and were you specifically assigned to assist at certain points in the Shanda Vander Ark trial?
I was accompanying her up here for the trial.
Okay, so you would assist in transporting her from the jail to the courtroom?
Correct.
And specifically drawing your attention to the last day of trial, which would be December 15th of 2023, do you recall a situation that occurred in the court services holding area?
I do.
Okay, could you describe what happened to the judge?
Well, I believe she was refusing to come up here during the trial at some point. And we decided that we would have a form made up that she was refusing to come up here. And I had our court services secretary draft for her to sign. And I took it to her, along with my secretary, notary public, in the holding area of the jail, where I found her, her attorney, Fred Johnson, and I believe a social worker in the cell together talking.
And so she had multiple people there with her at that time, is that correct?
That's correct.
And did she, in fact, sign the document?
She did.
And how was her demeanor while she signed it?
She seemed fine to me. If I remember right, I believe her and her attorney were just sitting on the floor next to each other talking.
Did anybody force her to sign this form?
No.
Did anybody threaten her that you saw or heard?
No, that's the exact purpose of the form that we had made up.
Okay. Did she appear to understand what the form meant?
Yes.
And it's your testimony her attorney was there with her?
Correct.
Okay. Do you recall any conversations that her and Mr. Johnson had that you heard?
No, I didn't. No.
Is that pretty standard that you wouldn't be present for attorney-client communications?
Right.
Okay. Protocol?
Correct.
Okay. Now, I know you answered this already, but you didn't threaten her to sign this?
No.
So I'm showing you what's been pre-marked as People's Proposed Exhibit 3. Could you identify what that document is for the record?
Yes, this is the form that our secretary typed up and I presented to her. She signed it, I signed it, and our secretary signed it.
Your Honor, at this point in time, the people would move to admit People's Exhibit 3. I would also note that this has been in the court record as Court's Exhibit Number 1 as well.
Oh, okay. Mr. Ambrose?
No objection.
All right, it's admitted, so this is Exhibit 3 for today's purposes. Admitted without objection.
And Your Honor, if I may publish?
I may. Thank you.
Deputy Levine, based on anything you observed with Ms. Vander Ark on that morning, was there a medical emergency that occurred?
Not that I recall.
And did Ms. Vander Ark make any comments to you about coming to court?
Other than she didn't want to come to court, no.
Okay, you heard her say that?
Well, yeah, that's why we were there.
Thank you. I have nothing further, but Mr. Ambrose will have a couple questions.
All right, Mr. Ambrose.
You mentioned that Ms. Vander Ark and Mr. Johnson were talking to each other.
Yes, in the cell, in the holding cell.
In the holding cell. Can you describe for me and for the court what the holding cell consists of?
This one particularly was a cell that there's no chairs. It's just a very small, single occupant cell. I mean, 5 feet wide, 7, 8 feet deep, and they were sitting on the floor. There's just a mat on the floor. That's where they have to sleep.
Okay. Was there... Were you there with Deputy Bassett at the time? Her name was Bassett. Now it's Evans.
Well, I've been around her throughout the trial. I don't specifically recall if she was standing next to me or not. I know our secretary was with me.
Who is Sergeant Vanderland?
He is a jail supervisor.
Were you aware that Ms. Vander Ark made her comment that she was suicidal?
Not to me. I don't know anything about that.
Did you ever observe her in a suicidal gown?
I have.
Was that on that day?
I do not recall if it was that day, but I've had to bring her to court numerous times, and I think she's been in and out of them.
Was there any request made by yourself or anybody that you're aware of that requested any type of medical assistance for Ms. Vander Ark?
I think some of our deputies have in the past.
On that particular day of December 15th, do you recall?
I do not recall if she needed medical help that day.
Okay, no further questions, Your Honor. Thank you.
Just a couple briefly that I apologize, I missed these on direct. Deputy Levine, are you aware of the video recording capabilities of the jail? That there are cameras?
Correct.
And unfortunately, is it true that there are no videos of the holding cell currently due to time constraints?
Correct. Once I was subpoenaed for this, I asked to see it, and apparently they only hold the data for 30 days if it's not requested.
Thank you. I have no further questions.
Mr. Ambrose?
Nothing further, Your Honor.
Deputy, whose idea was it to draft Exhibit 3?
I believe it was mine.
Okay, all right. When it was presented to Ms. Vander Ark, were you present? So my question is, did you walk in the room with the form, hand it to Mr. Johnson, and then she signed it? Is that what happened?
Yes.
Essentially? Okay. Did Mr. Johnson or Ms. Vander Ark ask for privacy to discuss the form?
I don't believe so.
Okay. Prior to the drafting of this, did you speak to Mr. Johnson? Hey, listen, you want us to type up this form or something, or was it more, hey, here's this? I mean, did he have any part in the idea to draft it or not draft it?
No, because I had it drafted before I got into the jail where she was being held.
Can you tell me why that you had the idea to draft this? I mean, what was the motivation behind?
Well, mine is so I wouldn't have to appear later to say I coerced her into saying something that I didn't want to go. I just, here, sign this, and
okay.
I would bring it up to the attorneys.
In all your, I mean, I'm assuming that while you were bringing people up and down, did you have an opportunity to see Mr. Johnson interact with Ms. Vander Ark?
Yes.
Transport or either up here or those kind of things?
Yes.
At any point in time, did they seem to be, just in terms of body language or things, maybe voices, did they seem to be arguing with each other or be upset with each other or having any disagreements with each other?
No, never seen anything like that.
All right. Seem to be getting along okay?
Correct.
All right. Including the last day of trial when he was talking to her in the holding cell?
Yeah, again, I'm in the area, I don't listen to what goes on, but no, I've never heard any outbursts, if that's what you're asking her.
Any follow-up to that, Mr. Ambrose? Or I should say, I think it was Mrs. Bloomquist. Any other follow-up, Ms. Bloomquist?
No, Your Honor.
All right, Mr. Ambrose, anything?
No, thank you.
All right, may this witness be excused?
Yes.
And Mr. Ambrose, may this witness be excused?
Yes.
All right, thank you, Deputy. Okay, well, that brings us to the matter of Mr. Roberts. Just in terms of, just as an offer of proof, Ms. Bloomquist, what is he potentially going to testify to?
Thank you, Your Honor. Yes, it's my understanding and my anticipation in his testimony that he has some testimony about some in-chambers discussions that occurred about the involuntary manslaughter instruction, as well as the commentary as opposed to admitting the entire video, as well as, I was unaware of this until just a few moments ago. Apparently, Mr. Roberts and Mr. Johnson went and spoke to jurors after the conclusion of the trial, and there was one juror who I believe was hesitant and took a little longer to convict, and her purpose for that was apparently to give credit to Mr. Johnson's strategy and theory of the case and the arguments that he made. So I think as it relates to the soundness of Mr. Johnson's strategy, I think that's pertinent evidence.
All right, Mr. Ambrose, are you objecting to the testimony itself, or just now it's being sprung on you right now, or?
I mean, I would like to review the transcripts and prepare a little bit better than just being sprung on.
And I will say, Your Honor, it was not my intent to spring it. It's just that it came up in a conversation naturally, and then I was like, oh.
I'm just in my head contemplating what kind of prep work. I mean, I don't. There's no transcripts of anything discussed in chambers. There's no transcripts of anything to talk to a juror. I mean, I suppose the only way I guess you prepare Mr. Ambrose would be to question Mr. Roberts, or at least because he's a witness, essentially given an opportunity to talk to him. I mean, is there anything other prep work you would do? I mean, I'm just trying to figure out what would the additional time yield for you in terms of preparation, just for that testimony. It just seems like there's nothing. If this was another witness who had testified previously at another hearing or had made other statements to the police, or I'm just trying to figure out what the time would be needed for, besides just general kind of catching your breath kind of thing. So
I like to prepare.
Yeah.
And, I walk into these types of hearings with a set of, an outline of what I'm going to, points I'm going to make and so forth. And off the top of my head, I have a few questions I can ask them, but, knowing ahead of time, I could probably do a better job at that.
Okay.
And I think we're going to come back anyways, and that'll give me enough time to think about it.
All right. Well, okay, so this is where the court's at. I mean, it's 3:00. We do have another 2 hours potentially. I am ready to go in terms of testimony, okay? Mr. Ambrose, it's my understanding that your client, and like I said, I don't want this to come up later saying that this thing is being delayed. I'm ready to take testimony. So if she's saying I can't do it today, and are you still requesting an adjournment to allow her to be in better health prior to testimony?
I am.
Okay, all right. Ms. Vander Ark, is that your decision?
Yes.
All right. Anything else, Ms. Bloomquist?
No, Your Honor.
All right. Well, we'll adjourn for today, and then Mr. Roberts hopefully will make himself available to Mr. Ambrose if he has any questions, as any other potential witness should. He obviously doesn't have to, but if he can, that would be good. And we will schedule this for another date, hopefully sooner rather than later. My preference is going to be sooner, so hopefully we can get this done. Anything else before we adjourn? Ms. Bloomquist?
No, Your Honor. Thank
and Mr. Ambrose?
No, I appreciate it. Thank you.
All right. I'm assuming, Mr. Ambrose, your client wishes to be here in person at the next hearing. Is that correct?
Yes. Correct.
All right. All right. All right. We're adjourned for today. Thank you.
All right, so that's going to put a cap on that. So Shanda gets up and testifies for all of 30 seconds, maybe a minute. She said she felt like garbage. She had a headache. She was nauseous. So she didn't continue doing her testimony. Then the state pulled up 4 witnesses. Her former attorney, her professional, like a social worker, I think, and then her driver, and then another deputy who testified that she was acting a certain way towards the end of the trial, or the last day of the trial, or first trial. And then there's a Mr. Roberts. So the state didn't want to spring this person on the defense, and the defense wanted time to talk to this person. So the judge is like, okay, let's give them time. Let's give them time to talk to this other witness. So I guess we'll be back. We'll be back again. So now, okay. So we've been wanting to cover this pretty much all year. I think when we were, whenever there's downtime, before we came up with the Ego Takes the Stand, we were doing rewatches, and Shanda is definitely on. She's also on our radar for Ego Takes the Stand, because I know she takes the stand. So we'll do a rewatch of her now that we got a taste of her. I just saw little bits and clips of her here and there. Now we got a taste of her. I'm thinking, Brian Walsh starts Monday, so we're definitely covering him. And as sad as this is going to make me say this, it seems like the holidays, meaning Christmas and New Year, we're going to have time to watch. So that might be kind of brutal to watch around Christmas, but that might be our only time that we can watch it this year. I don't think Brian Walsh is going to end. I think he's supposed to go into Christmas. I think that's going to be like a 3-week trial. If he ends early, then we'll cover it. Well, we'll do Shanda then, but again, it's going to be towards Christmas, which might be kind of weird. But that might be the only time we can watch it. So if you guys are cool with that, let me know. Northwest, you're saying, yeah, let's do that. So you guys would be okay with it if it's around Christmas time? Kelly and Jonah? I know. Glad we're covering Walsh. Yep. Dragonfly. Ronald Ambrose. Okay. All right. Thanks, lazy boys. We'll fix that for the trial. All right. If you guys are okay with us doing it around Christmas time and New Year's, that seems to be, depends on how long Brian Walsh goes. So, no, it's okay. No, appreciate that. That's cool. Thank you, lazy boys. Dragonfly, you're good with that. Sarah, you're good with that. Jenny Lynn, Yeppers, Alice, absolutely. All right. Southern Heathen, her trial was so hard and stomach turning. All right. If you guys, Jen Pookie says, count me in. All right. Good with me, Jenny G. Good with me, Jenny G. Stolly. I'm not going to be able to pronounce your name. JMS, that's good. All right. Cindy, all right. Put your pitchforks away. I get it, man. Trust me, I get it. It's just sometimes this gets to be too much, you guys. Just sometimes it gets to be too much. But I have to say thank you for responding. You guys were really good there the last half hour. So I appreciate that. So look, trust me. I know. I get it. I know. Just sometimes we just have to take a step back. So that being said, let's go over and watch Johnny Depp, because we still have about an hour and a half of Johnny Depp. So I know there's a redirect set on. Come join us over at Johnny Depp. He's on redirect. I think, we still have about another hour and a half to go with that. So thank you for watching Shanda Vander Ark. We don't know if she's good. We don't know the outcome because she still needs to come and take the stand. And then we're going to have another witness, Mr. Robinson, I think. It was Mr. Robinson. Mr. Roberts. He still needs to testify. So we'll cover this again next time it comes up. I don't know when. They didn't say when. So we'll be sure to stream that. And it seems like you guys are okay. We'll do it over Christmas. It seems like when Brian Walsh ends for the holiday break, we'll pick up on Shanda and we'll stream it then. So until then, please join us over at Johnny Depp, and thank you to our mods for creating a nice safe space for everybody. Thank you to you guys, chat. Really appreciate you and respecting each other, respecting our mods, respecting the channel. Means a lot to me that you spent your day with us. Thank you. And thank you to Aaron for creating all the graphics. And with that, if we don't see you over at Johnny Depp, have a great week. We won't we're going to do Ego Takes the Stand. Obviously, we're doing it right now. We'll do it Wednesday. We'll take the break on Thursday, and then Friday we'll be back. We'll do Amber Heard Wednesday and Thursday. So if you're not into that, you don't want to watch it, we'll see you at Brian Walsh on Monday, December 1st. So hopefully we'll see you over at Ego Takes the Stand, and if not, we'll see you at Brian Walsh. All right, guys, have a wonderful holiday, and we'll see you again either at Ego Takes the Stand or Brian Walsh. Take care, guys. Bye.